So hello everyone, welcome to Sherbrooke University. My name is David Pavot. I'm a professional, I'm a teacher in professional rights and an anti-doping in sports, and I'm your host today. I have the privilege of welcoming you all today for this meeting about the international responsibility of the states in anti-doping in sports. As you know, this conference is in the frame of Charles Rousseau, who's a simulate in sports today, and we have the chance today of welcoming about 150 people coming from all the French-speaking world. Today, we're going to have some speakers that will speak French and English. Therefore, we have translators. If you are in the room, you can take the headphones with translation, or online, click on the icon of interpretation so that you can have interpretation, simultaneous interpretation. So organizing a conference is not an easy thing. It requires means, which is why for this meeting, I want to thank the titular of rights represented by its president, the Professor Valère Ndior, and the three people who allowed this meeting to happen, the University of Sherbrooke and the Master of Politics, Applied Politics and Rights by Geneviève present here. The Center of Study of Quebec in Montreal about the sports, several professors here in the room today that we will be able to hear today. Several professors are members of it. We see Geneviève once again, Christine Plouffe-Malette, myself, and the managing school in Sherbrooke, where is that anti-doping school in here. We have some also partners, which is the Council of Research in Canada, who allowed the financing of that colloquium meeting, and a specific partner, Mainguené Foundation, who will be able to talk in a couple minutes right after Charles Valère, who comes all the way from the Atlantic, who is the leader of that international meeting here. Thank you, David. I think we should thank you for taking on this load of work. Thank you. I'm going to be quite brief. Welcome to everyone here. Dear friends, colleagues, members of the member Charles Rousseau. I want to associate to David to welcome this 19th Conference for International Rights directed by David Pavot, who is the theme of the international responsibility of the states in terms of anti-doping in sports. I'm going to be brief because we will have later a ceremony, an opening ceremony with a cocktail of nations. We will allow to explain a little bit what's going to happen during the week. But I wanted to bring a welcome to David Pavot and all the team that organized for all the reflections that we're able to bring and start from now. This is really going to contribute to that network to add to the learning experience also a scientific research, really fine about that theme. We're really happy to have that theme because it allows for a couple months those people to think and to relate it to the sports rights and the international rights, especially a couple months ago from the Olympic Games of 2024. I wanted to thank and celebrate David Pavot and his team. I think you will be able to go back to the work that was done, and thank also the support of that meeting, DPA, and also the Center of Application on Integration. And the last word about the teams that are represented, different institutions across the world. First of all, welcome. I think that you had a nice trip and that it happened in the best condition. I know that some of you are still bothered by jet lag, but I hope that you're going to go through it quite well. Little warning today, which is usual. Everything that will be said during this half day of studying is quite possible to maybe influence the judges in the games later. So maybe be careful about some doctrinal elements that could come up during the discussions of practitioners. This being said, thank you for the organizer for his work, and may the work start right after the couple speakers we're going to hear. Thank you, Valère. To start this conference, we have two people that want to let us know something. They're online, Danielle and Marc from the Foundation Anthony Mainguené. They accepted to finance largely this conference. So Danielle, Marc, we see you online. Thank you once again. And we let you introduce yourself a little bit. We listen to you and thank you for your support. We would have liked you to be here, but I know it's far away and it's all the way across the Atlantic. So we hope that we can welcome you once to Montreal. Everybody's listening to you and looking at you. Hello, David. I don't know if you can hear us well because we hear very low. Maybe it's a problem of connection. I don't know. We hear you very well. Okay, perfect. So I really wanted to thank you for allowing us some minutes to present you the foundation and talk about the ethics, especially about this important framework, which is the sports dimension. Briefly, hello everyone. Danielle, my wife and myself, we know the names of the Anthony Mainguené Foundation. We want to thank all the organizers and especially also David Pavot for their engagement. We know how hard that is actually of organizing a conference, especially this one, about the international responsibility of the states in anti-doping in sports. Above all, today in our society, where the human dimension is the sense of values tend to go down, the ethics is important now, especially today in sports, which is the same thing that the Foundation Mainguené has to heart. It was created in July 2015 in the Foundation of France to promote the ethics elements of Anthony Mainguené, who died of a heart attack at 40 years old. He was an expert in network and cybersecurity. He was a leader of cybersecurity in the information system. His skills and managing skills allowed efficiency at work. His integrity were really appreciated and agreed by all, which is why we want to continue his work by the new Aquitaine region wants to continue that ethics understanding by training men and women who will be fully capable with a critical mind to raise up the great challenges of our time. It wishes to bring awareness that ethics can only be realized by action, because our world is changing and ethics allows us to ask ourselves questions and to be fully responsible, equity and respect of the other person. To do so, the foundation has 5 rights: numeric, human science, and development. It has conferences, it supports conferences, meetings, just like the conference and the Quebec meeting that we thanks. And also recently was created about the work, there's going to be an important conference in Bordeaux and Quebec in June. So the foundation is supporting works, often the problems of such big problems in the world, in education, institutions, etc. 35 events were supported last year. We would like, of course, that you can go see the website of the foundation to know a little bit more about it. But since a couple years ago, since last year, we haven't been able to update the website, but you can still look at it. We are really booked. Indeed, today, we are living through a time of worry. It seems, therefore, that for the good of everyone and the future of our humanity, it is important to think again of what is society, what is the problem, and our way of thinking of being. The Foundation Anthony Mainguené hopes that these ethics, in a spirit of respect of human rights, can lead to better understand how to live. We also wish it in the world of sports, because sports is effort, exigence, going above yourself, and courage, and also letting go of yourself. It's also integrity, respect of each other and yourself, value of example, and this is also an ethics problem. The lack of consideration of yourself, the illusion of success and health risks, or it's about doping. So to find those values again, which makes of the sportsman a man who can be proud of himself, to allow through education the equality of chances, of justice, and of course the engagement in the behavior, the ethics can be a lighthouse to light this problem. I'm going to finish this with two quotes from Juvenal, first of all, a Latin author who was repeated by Coubertin. A sane spirit in a sane body. And then the second quote, who shared this hope of a world from many ethnics and who's open to the consideration of everyone. Humanity is a responsible adventure which goes through the other world and only lives through the other one. So in the name of all the members of the foundation, thank you for listening to us and putting this conference to work. Dear Daniel and Marc, thanks a lot for your support and your nice words. I hope that you will stay online, even though it will be quite late for you in France. But of course, you're quite welcome to stay online with us and enjoy that conference, which is going to be, of course, recorded and placed on video platforms so that you can continue to watch it for everyone that's interested. Without waiting, because we're on time, I'm going to call Valère. I'm going to invite you to leave the platform, and I'm going to invite Cécile Chaussard, Master of Conference in Bourgogne University, expert known and from doping in sports. She's a counseling in the French conference in the French University. Aboubacar Dapiquet. He has a master's doctorate in rights. Mathieu Maisonneuve, professor in Aix-Marseille University, a great expert in sports rights. Right now, he's doing research in doping in sports. And he's in orbit at a referee at the sports. And the last one, not the least, Franck Lati, professor at Paris-Nanterre University, redactor of Charles Rousseau of this year. So it's through him that you're going to live martyrdom. And also Frank is also an expert known in public rights and sports rights. He's also a referee in the international referee sports. This first meeting is going to go about the roots and how the countries limit themselves in sports and doping. Maybe you didn't follow the news. I see that there are a couple spies in the room from the MEA, World Anti-Doping Agency, but it's a topic that's really on time. In 2014, we realized, kind of stupefied, that some practices that we thought we're over with were happening in today. And following this, the sports world tried to react with sanctions adopted according to the anti-doping Russia, etc. The sports and international community tried to react according to the UNESCO and the World Anti-Doping Agency, trying to develop a strengthened framework with the government. We didn't have much success, actually. And today, this questioning about the responsibility of the governments in terms of violation of the anti-doping laws is a subject that's quite relevant. Relevant at the UNESCO because there's a work that is really placed that tries to strengthen that responsibility framework. But in the WADA, World Anti-Doping Agency, 2 meetings were held in last March. We were talking about that question. And there's some questions rising about the next opening of the rights of anti-doping. We know it's happening quite often, and this question will come back also. There's some also reports that were published. So the question is here. Before setting up a responsibility right, we have to ask first, what are the rights, the obligations of the government? Are there any? Are they constraining enough? Too constraining? I want to ask the question to my fellow speakers here. At the very basis, we know today that the doping fight is double. We have a system that is constructed by the World Anti-Doping Agency from Switzerland, and we have a system also. We have this World Anti-Doping Agency that connects both between all the different states. So the fight against doping, I'm going to go to Cécile. Is it right? Is it not true? Can you share a couple words about it? The mic is turned off. I'm going to ask the technician. It's recorded, and for the translators, they're going to need, otherwise they won't hear you. Perfect. Okay. Thanks a lot. So yes, indeed, regarding to the construction of the dispositive of anti-doping, there's no doubt about the fact that actually it's the sports movement who put it in place for a simple reason, because not linked to the doping, but because of how sports is created and the origins of that movement. Federal, of course, but also through Olympic. We have to understand that the states did not participate to the construction of the sports system. The sports system put itself in place by itself. I'm not going to describe the story of modern sports, but so some clubs created themselves through universities, of course, and then those clubs reunited to meet. And when you meet, we need some rules, because if we don't play according to the same rules, then it's not the same thing, because the sports is a comparing of results and performances. So created federations who are in charge of putting those unique rules of games, first of all, and then the national, of course, national federations were not enough, because we have to compare the performances outside of the land. So we had the international ones, and we had to put all those rules back in the game. Of course, we had only game rules. Of course, sports evolved, and when the game is evolved, well, the federations created more and more rules that are not only technical game rules, but also in discipline. Now, what is the fundamental principle? That sport system was created for competition, to organize competition. When you go to run alone, you don't have a license from a federation, you don't need it. But if you participate to a competition, you have rules that are fixed by those federations. So those federations, then the CIO were created for this purpose. Now, there is a foundational principle. The participants have to be equal. We have to compare performances loyally, which is what we call the loyalty of competition, the equality of competitors. That's the base of competition. Otherwise, competition doesn't make sense. Otherwise, we can't compare performances if we are not in the same situation of equality at the beginning. And here, doping, when it happens, it happens quite fast. Sports people always dope themselves. Of course, maybe we had some music, oh, it's the money, the business, etc. No, the first case was in antiquity. So there's no problem. Why do we dope? Because we want to win. There's money, there's no money, we want to win anyways. Even if there's no money at the end, you have some people, old people who run marathons who are 75 years old and they use the dope. It's not for their age, for their glory, you know. But when doping happens quite early, we realize it. Also because there's some terrible accidents and there's deaths, and we can identify the death because they took substances, whether it was drugs, etc. It's quite the opposite of the principle of equality of the players. It's of that principle of equality. So that federation had to react to cheating. So it had to realize how to act against cheating. So Abu Bakr, how was it reacted? The rights of sports reacted to create the sports rights. Maybe I'm going to talk about, right now we are talking the sports right. We're not talking about the interstate rights. Well, we start to identify anti-doping laws from the very, very beginning, not what we know today, of course. In 1928, the Athleticism Federation started to put in place some rules, but we don't have any substances that are identified. We don't have a list for all the disciplines. We don't have any tests, of course. We don't know how to test. So that's going to take a lot of time. And finally, what we need to realize in that understanding through the sports is that it's something that is not linear. It's something that reacts to some events where we say, actually, well, sport is not that. Sport is supposed to be something healthy, good for health. And we realize that it's something that is the opposite of healthy. And one of the first elements that is going to make the CIO react in Rome 1960, we're going to have the death of a cyclist during the games. And it's not acceptable. It's not acceptable for the sport movement, but also for the public. The CIO reacts to that death, which is, of course, related to doping. The CIO is going to vote in 1962 a first law, but it's really the first of it. Maybe back then, Cécile, if I'm not wrong, tell me if I'm wrong, but we're not talking about of equity, but we were talking about health protection, actually, because it was death the problem at the very beginning. What caused that? Now, of course, the first regulations and laws was, okay, we need to be equal, but the real resolution was because of a death that was due to drugs, which is why we have that element of health protection. Now we have two foundations, and it's the two same in the anti-doping fight, equity and health protection. They're both now. And it's ever since that element. On my left, Frank. Now, what about the sports movement today? Does it fight also for anti-doping? I'm kind of jumping on you. Well, today we are in the regulation. The states started to get implied in the anti-doping law when there were deaths, because you have public health issues. It's not only equality of sports, etc. The states are not really attached to sports. It's not their mission in and of themselves. But when you have deaths on the Tour de France or Olympic competitions, you have, of course, health problems that lead the governments to engage in the anti-doping fights. And because you already have the sport federation in that middle, we have to know how to cooperate in order to fight against doping. And it starts ever since the 80s, actually. I think the Canadian government was really involved for a first cooperation with the CIO, saying it was right after the Ben Johnson. Maybe you were not born, but it was a big Canadian who was positive to drugs in Seoul in 1988. So big scandal. It was 100 meters that he was a sprinter. He had won the medal, gold medal, and we realized that he was disqualified because of drugs. A real scandal. And the government, Canadian government, was really concerned by the question. He worked with the CIO, and that's where the work between governments is going to start with the sports federation in order to find a way to fight efficiently against doping. I'm just stopping you because I'm going back to Abu Bakr, who started to tell us that in Europe also, the Europe Council appears as an idea laboratory. They have a regional meeting because it's also open to the other states. In anti-doping, can you tell us a couple words about that convention? Yes, it's the convention of the Council of Europe, which was done in 1989. As you said, it helped as a brainstorming for the anti-doping laws of UNESCO. It was the first multilateral elements to allow building a frame between states and the federations of sport. What is nice about that, interesting about that convention, is that it lists elements that are forbidden. So we start to see a harmony between those laws, and the UNESCO is gonna use that Convention of Europe law for different aspects. A first brainstorming possibility. We see also the debate that is starting. Mathieu Delaneuve, I wanted to add that there was a middle ground period. First, it was the sport movement that launched the premises of the text for anti-doping in the 20s, 60s. And then Frank was explaining that Canada tried international cooperation, which was with the convention, which we talked about. There's a middle in between. There's some states, for example, Belgium, for example, France, in the 60s. In my knowledge, Belgium started it first by a national law, anti-doping law in 65, and then France does the same couple weeks later in June 65. So we have that moment where the federations do it, then the states start to work on themselves, and we have a fight against doping, which is quite fragmented. Of course, which is what the WADA is going to do between the states, link the states and the sports movement. Those two laws, Belgium and France, which were well-intentioned, maybe caused more problems than they resolved them, for a simple reason that France and Belgium penalized doping. Now we have discipline problems. So if athletes today have doping, discipline consequences, if we say, or a fine, etc. But back then it was prison consequences. Of course, according to the place we were doped or the amount we had quite a different, sometimes penalty, sometimes we could have prison, theoretically, of course, because those laws were almost never applied. Never in my knowledge, a jurisdiction from Belgium or France sent someone to prison because they doped themselves. So we had laws that were very repressive, that in practice were never applied because the sanction, the penalty was too strong compared to what was done. So we had those couple initiatives from the states, of penalties that were not adapted. And we wanted to put an end of it with the European Council Convention and then the Convention of UNESCO of 2005. Just because you really give us the way of making the link between that period, between the 60s and 80s, let's say. What's really interesting is that when you look at the Council of Europe, the Europe Council, we talk about that convention, 1989, it's an interesting one, but the EU Council, the first resolution it did against the sport was in 1967 about doping. And when we talk about the states and the sports movement, 1967 is what? The creation by the CIO of the medical field the first list of doping elements. The first controls organized in the games were made by that CIO regulation and were created in 1968. So between 60 and 80, parallel to that, there is an exchange between states. But at the same time, we see an evolution that is parallel with the states and the federations. Of course, we're not limited because from the beginning, we are on a cultural convention that is about 50 countries. Then the European Council is going to continue, 79. We have problems of tests, problems of checkups, but still the Federation of CIO continues to put in place elements for competition. We have a second date, 81. 81 is the Congress, one Olympic Congress, which is Baden-Baden Congress, where we add again that the doping is the first problem of sports. That's what it was said. And straight after that, the European Chart was created by the European Union, meaning that the Council of Europe listens to what the sports team is doing and reacts also through the states. And the European Chart Against Doping in Sports, which was, of course, negotiated by 1881 and arrived in 84, in parallel to Baden-Baden and 88. What happens? Ben Johnson, as you said it, problem in the Tour de France, leader is considered positive. CIO reacts. 88, new reaction. And then European Council, we need a convention. So in that period, we have a parallel action, and a beginning of cooperation. Of course, we're not in the water area, but each of them, without listening to each other and talking, they were acting. And the European Council said that the responsibility belongs to the sports federation, but the states have to encourage them. That's quite clear in their text. Frank, you wanted to say something. Then Matthew. To add on to what Cécile was saying, what's really interesting is that the action of the states, the collective action of the states, you're international rights jurists, so there's not a lot of stuff. There's the soft law, the Convention of Europe, but the real element is occupied by the sports organization and the CIO. He's the one who's going to try to harmonize this, because each federation had its own laws, its own procedures of control, its own list, own sanctions. So it was kind of going everywhere. There was no easy way to read it. And the CIO, from the end of the 80s, is going to try to harmonize it. It's going to adopt a medical code, make it so that it becomes the rule. It doesn't have much success. Then you have an anti-doping code of the Olympic movement. Also, some federations are going to adapt because the CIO has some arguments. I mean, the Olympic Games can convince them of adopting it. But in the Tour de France in 1998, we have a situation where some rules are harmonized about for example, the FIFA had its own anti-doping laws that had nothing to do with the CIO. So the norm is really occupied by the federation. This is not public rights. It's the rights of sport in that case. But the international rights existed by the Convention of Europe, and is going to come later by the UNESCO Convention, who's going to normalize those activities. Matthew? What we just said, of course, this reminder of history, of that fight against doping, is interesting in the past, but it's also interesting about the future. If we resume what we just said, it's that it's always more cooperation. Try to avoid initiatives that would be separate from a state and federation. That's what the history taught us. And now with the Rodchenkont Act, the law about the doping that the United States voted a couple months ago, we have a little bit of a turn back in time with a state that decides for good or bad reasons. We could discuss about it, but a state that decides to do things on its own about this question. Is it a good thing? I don't know. Is it a bad thing? I don't know. But we're kind of going back in time. I see Frank is about to jump on his mic. Right now we're in 98. So we talk about that scandal. And then we say, if I go back to what Cécile was saying and what Abubakar mentioned, there's that parallel construction that's happening. And now we're going towards a collaboration. What happens after 98? In 98, are we still in a correct regulation together? Because it was kind of considered as the starting stone for anti-doping rights. After 98, you have 99. Awesome. And 99 was the creation of the World Anti-Doping Agency, WADA. 98 Tour de France is going to be like a starting point in world sports, because we're going to discover that a lot of cyclists were doped. There are some French people who were preparing the doping material, so the governments are implied. And the scandal is brought to the light. And they're scared that so the Olympic team is going to react and is going to start an international conference in Lausanne, beginning in 1999, that should have all the governments and the sports team. CEO was also deep in some problems, the scandal for the attribution of the games of Salt Lake City. We realized that some CEO people were bought so that the vote could be bought for Salt Lake City. So there was kind of a problem. His moral authority was not very good. February 1999, Lausanne Convention had kind of mixed reactions, but the decision was taken to create an agency, World Anti-Doping, that should bring in the states and the sports. They also wanted to bring in some pharmaceutical sponsors and teams, and it was not well received by the states. But the principle was there's an agency that's created, it's decided, the CEO created it by under the order of a foundation of Swiss rights. So the agency at the beginning is not independent from the CEO, but over time the status is going to advance and the states are going to get involved. And the principle of that agency is to have that's participation of both the public states and the sports organization equally. The mission of that WADA is to substitute the CEO in the direction of the fight against doping. It's that agency that's going to take those responsibilities. And the first one was to elaborate the World Code Against Doping that you must know all here, which became the reference text, which substituted it to that rule. But there is the old Olympic anti-doping law, and the new one now. There's a lot of things that are in common. Of course, it went way further, and the whole issue actually is to be like, how authoritarian is going to be that code, especially in terms of governments. Abubakar, actually, I go back to you. We didn't hear you a lot. Frank was asking, what is the authority of the code in terms of towards the government? I know you worked in it in your thesis, in your recent research, because we talk about an instrument created by a foundation of Swiss rights. So for us, international jurists, we have a problem to categorize that thing. It's not an international organization. Kind of struggle. But how did the governments, how are they targeted, and how do the governments how are they associated to the code historically, first of all? First of all, historically, were they associated? Did they ratify it? They didn't sign the code today. So yeah, no, at the beginning we wanted to associate them and condition the organization of the Olympic Games according to the ratification of the code. It was a private instrument, so I think they were maybe a bit of apprehension from the states to give a judicial force to the code. So it was asked, okay, for the Olympic Games, should the states ratify the code? And eventually, it ended up on the Article 3 and 4. They should. Now you're talking about the convention. We are already further. So what I understand is that in the first version of the code, which should come in effect for the 2004 Olympic Games in Athens, the question is, 2004 we had to sign to participate the games. And the question was, after 2004, the states, should they have signed it? What I understand from your answer is that the states did not sign the code. Why? Because it's a private instrument. And judicially, it's hard to do it. So I think they went through the UNESCO convention. Because it doesn't correspond to the architecture of what we see in international rights, the states were like, we cannot sign or ratify this because we don't know what it is actually. Therefore, the choice was to go to UNESCO. And why do we go to UNESCO actually, Matthew? Why do we go to UNESCO and what do we do in it actually? For doping, and what happens in there after 2004 actually? About the question, why did the states sign the UNESCO law? I guess there's an image point and consistency and judicial. After the Festina scandal that Frank was talking about in 1999 Tour de France, people kind of were saying, okay, we're sportsmen, you're supposed to do something, it doesn't really have anything, it doesn't really do anything. So we're going to say something. But after just saying that, it's hard for the state to say, okay, something happened, Lama, the code, but we don't sign the code because we cannot, for a certain reason, to suddenly negotiate and sign the convention of the UNESCO was a consistency that they themselves were involved in the future of it. Then there's an image question for those who joined afterwards, the UNESCO conferences, because you had first signers and then those who arrived later. It's in order not to appear as though you were alleged with the sports convention. Kind of staying back seems that we are a country in which sports is not its own. We don't want to engage in it. There's also a judicial question. In the code anti-doping, I don't remember the article number, that a state which didn't sign the convention of UNESCO cannot welcome any international sports event. We could say, okay, whatever, because the code does not impose itself on the states. They didn't sign the code. It's indirectly it applies, but yeah. But who chooses where the countries are selected? There's a CIO who signed the code, and the sports conferences who signed the code. The Olympic national committees are the one who participate. So the people who signed should not attribute sports events to states that did not sign the convention, whether there's a real judicial point for it. So there's more than 180 countries who signed and ratified that convention. I would say to end on this, that they have less reasons to not sign the convention. Maybe to say it brutally, it doesn't engage too much, actually. And by that, I mean that there's no mechanism of control of the respect of the convention. There's a simple system of reports based on a self-evaluation by the states who signed it. But in the disposition of itself, Most have the soft right. The state encourage, facilitates, promotes. And for the couple dispositions who are more constraining, couple 1, 2, 3, about food complements, for example, about the relatives of the sportsman, about the principle of the code that the states should normally respect. Those dispensations who are more according to the norms, because the states engage themselves too, they are quite blurry actually, meaning that it's not too constraining. It's not the problem, it's the content of the obligation. And we will be able to continue to talk about it when we'll talk about what does the code mean that the states meant to respect by signing the UNESCO Convention Code. And Matthew, to go back on what you said, the UNESCO Convention does not talk about the principle of the code. It talks about, it's more precise actually. The convention mentions that the states engage themselves to respect the principles said in the code and not the principles of the code. Maybe there's a question here that's more dynamic and larger here. I know that, Frank, you thought about the principle, and Cécile too. Maybe we can ask you, the states, what are they committed to in that code? Because on top of that, to complexify things, the code is evolving, so we have new principles who appear. So are the new principles given to a private entity? And so now all the states are all, okay, you do what you want and we don't look at it? It's the beauty of international rights, actually. When the states have a problem getting together on something, they agree on a saying that could eventually mean several things, but something that's going to be agreed with by everyone, which is going to satisfy something if you want to be more strict about it. So during the negotiations of the Convention of UNESCO, there were some disagreements about the authority of the anti-doping code. Some states were really far and some didn't want this private instrument to be opposed to sovereign states. Formally private, of course, because they were on a foundation of Swiss rights, even though it was equally created by rights and by sports team and the states. So we had negotiations. I don't have the secrets of the negotiations, but globally, that's saying, okay, the things said in the code and not. It was what was adopted. Now it's all to interpreters to believe and say what you think is in there. The question is really there, and you're here also. You can give your interpretation. What are the principles named in that code? We can make it say what we want. Now we have a judicial question, but also a linguistic question, because the terminology can mean some other things in other languages, actually. That's maybe a food for thought, but it's not the same thing in French, English, Spanish, German. Cécile, on the principles, I think that, of course, there's what you said in terms that every state didn't agree. They were not in the same line of thought of being imposed or under that private right, even though they participated to that redaction, because they were in the WADA and they were invited to give their observation when the code redaction was placed. But I also think, and maybe it's not what was done at the beginning of that term, but I believe that it represents well that hiatus that's present in the fight against doping, and that link between sports movement and the states. Meaning at some point, why are the states interested in that fight against doping? The equity of competition, of course, every state is attached to that, but honestly, it's not a problem in terms of a state that competition should be equal and loyal. But ever since the doping, and that's what happened in Festina in 98, Festina, it's not only, okay, there's a cyclist team that is doping and maybe the other ones. We take products, police, the operation doesn't come from the sports element, it comes from a state, and it comes from a police area and customs, and it's a traffic of product. We are in a trafficking area, problem, maybe money laundering. So it starts to interest the states, actually, who say, okay, if there's no correct fight against doping, now, of course, linked to the competition, but that have if problems and link outside of the competition, the states have to be interested in it. But at the same time, the states won't be interested about the rule of competition itself. But when we read the worldwide code, it's linked to sports elements. It's not linked to money laundering, even if doping is a trafficking, but it's linked to the relatives of the sportsman, the trainer. They need to be in a loyal competition. So technically, it's always a little bit that problem, meaning we have the competition, and it's really the sports movement who's in place to know what they need in terms of sports interests. But at the same time, there's a sports cheating that has impacts on elements that interest the state. So they have to agree all to fight together, but against different elements with different goals. So maybe is it going to be able to apply the code in itself? We are one of the states in France that applies the best the code, and yet it's really, really difficult. We ask, okay, is it the sports team that should apply it or the state? And of course, each team, according to its priorities, is going to put in place what he wants. We don't want to put anything clearly for every state. For some state, it's going to be trafficking. For some, it's going to be competition. So maybe that formulation helps the states not to be too determined and to determine what's important for it. Matthew, you wanted to add something? Because you're the one actually who started the discussion. I wanted to add something, but I also wanted to say something about what Cécile just said. It's true that every state puts what he wants in it. So that blurry element of the principle said in the code is, of course, convenient. All the text adopted in France, all the laws recently was law of transposition of the principles of the code. But in those texts, we don't transpose the principle, we transpose almost all the code, meaning it's a way, sometimes easy, to make us think that we have, because of the Convention of UNESCO, to retake all the code when we don't actually have to. It's easier to say, okay, we do this because our international engagements ask us to, rather than to say, well, we submit to a private text and now an institution, hybrid institution in the sport movement. Now we close the French elements, but maybe we have a policeman of the convention who needs to be convinced when we talk about that fight against doping. They have a talk to talk it for it to be transposed, because in Canada the transposition is the WADA, which is a private state, puts it in the Canadian element, and that's it. In the continental system, there's France, but also there's other ones where we have to transpose it, to add it in our law, and to convince the judge, also the state council, or eventually the constitutional state if there's discussions. We attach that to the convention to demonstrate that there's some engagements. When we talk about the French jurists against doping, they also say themselves that sometimes they do some hard exercise to convince the judge that indeed it's principles that are correct and that they fit into this text. Yes, there's two categories in the state. There's the states that don't intervene, for example, the English speaking. And their role is mainly of not putting any blocks on the road of that code. For example, in South America, etc., Italy, the state has to adapt the rights so that it can be applied by the sports elements. the principle said in the code. That's what is said by UNESCO Convention. First problem, what is the principle? What does it mean? Even if we stick to the juridical element of it, there's a colloque in Lyon in 2007 about the principle in rights, and the first part was about 100 pages, was just about what is a principle in right. We can hear it as meaning rules that are not judicial, moral laws, political, etc., that are at the base of judicial elements. For example, we could say that some principles of the code is harmonization, cooperation, equity, with maybe a problem to separate the principle of values and principles. And David wrote it in an article that American law is opposite actually to the law because it's opposite of cooperation, of harmonization. And then we also have the principle in another side, in Dworkin, that distinction between principle and rule. The two should be judicial norms, but the principle should be rules that are more abstract, structural, while the rules are norms that are precise about that point. So first of all, what is the principle? Second problem, principle said in the code. If we understand what is a principle, what are the principles of the code? The principle that the code doesn't say, there's no definition in it. Of course, there's some article in the code that's make reference to something that is called principle, but is it made voluntarily? We don't know, because those principles that are stated in the code sometimes are details such as the suspension, provisional suspensions, education points. So what are the principles of the codes? And then last point, but that Frank made me think about it a couple weeks ago. Does the UNESCO Convention make obligatory, mandatory to the states all the principles said in the code, or only some principles stated in the code? When we read not the third article, but the fourth article of the convention, it said that the states are required to follow the principles stated in the code in agreement with the elements mandatory in the code. So meaning that it would only be mandatory for the state that the principles of the code would only those in link with obligations contained in the Convention of the UNESCO. But the Convention of the UNESCO does not deal with all the aspects that we find today in the code. So there's three problems here to understand what principle stated in the code means. I don't really have an answer for each of them, but it's a notion here. There's two jurisdictions that pronounce themselves quite indirectly, quite accessorily, on the notion of code principles, principle de tasse. There's a sentence in 2011, and then the German Federal Court in Pechsteiner case 2016. Both of them very indirectly, was not the main question that was asked to them, but well, to the sentence, we can read it somewhere. They concentrated an element of the code, which is an appeal to the task in international cases of doping. Maybe we shouldn't say more to them to what they say. Those decisions are not principle. But it seems that those two jurisdictions understood that there's an answer to all three elements. Principle, it's a judicial right. Principle of the code can be something else, that's something that is literally identified as a principle by the code itself. The code never says that the task is a principle, even though we could understand that it's something that's structural and general. And then those two jurisdictions don't seem to consider that the principles that the states are required would be only those linked to the convention, because in the convention there's not much that talks about the intervention of the task in those cases. So here we have a jurisprudence. Of course, there's a lot of precaution here, because it's not about knowing if a state or not respected the convention, if he respected his obligations, etc. But we have the beginning of something that could be an interpretation, not an authentic one, but maybe of what is a principle stated in the code. Abou Bakr, quickly, and then I'm going to ask one last question before asking questions in the room. I'm sure there's questions. We're still not sure about what principles are. Of course, you understand that. We're going to talk about it this week. That's why I kind of go backwards about it, regard to what St. Matthew. We cannot empty a convention of its meaning saying there's no principle, especially if it's not judicial principles. Otherwise, we would empty the meaning if we say it's judicial principles and not legal. So I think there's a global understanding of the dispositions. We talk about harmonization, cooperation. We could say on the opposite that the objective of harmonization comes from transposition. That's what I'm saying, yes, in both senses. Even if we hear it in the sense of non-judicial case, the non-judicial rules that are present, by harmonization, it's a principle. Loyalty is a principle. Good faith. Abou Bakr? And then I will ask a question. Quickly, I would say that the notion of principle and the lack of definition was also made so that it could be adapted to the evolution of the fight against doping. For example, the ones who throw the whistleblowers, who the protection of whistleblowers is interesting in the last laws. The protection of the whistleblowers, maybe the students or the audience would like to have your advice, your understanding. I think there's other dispositions that were focused in the last code. Maybe I'm going to take that opportunity to talk about the power of supervision, about the WADA to supervise the conformity of the organizations against doping. I think it allows for the agency to define some principles. So for example, the one you talked about, the courts, it wasn't the WADA decided that France was not correct on that. For example, about that example, I could also talk about, I think during the last transposition, we were talking about the strengthening about the inquiry of all that elements. I have a question that is maybe more precise, and that's kind of brought back my idea here. That was raised by what Cécile you said. You said the code doesn't have application on the states, but in an international of a judicial part, maybe there's the code and the standards present are applied to the states. If we are in a judicial laboratory, a lab for anti-doping, they have subventions, the director is named by the government, there's public state. We could say that the code can be applied to the government directly. Even some international organizations, again, anti-doping, who are members of the state or integrated to ministries, which is why we have kind of a different position here. The code anti-doping, the movement says it should be independent things, kind of closing the eyes, important independent organizations. But when we take the perspective of international public rights, as a jurist of international right, it's okay, it's members of states, and when we test, okay, it's governments. I go towards Frank because I know you have an expertise in between both. So what should we think about that? Because Cécile was saying it doesn't apply to states, but now what would be your perspective? When we read carefully the code of anti-doping, we understand that indirectly the governments can be concerned. We talked about the agencies against doping, where there's Article 22 that lists the requirements of the people signing, for example, the anti-doping federation, sports federation. So all the people signing the code had expectation. They're not obligations, but there are expectation in the government towards the government. And apart from those expectations, through the labs, through the WADA, through those people signing, there's possibility to add indirectly through to act on the state. So I'm going to cite one again. The French state was not in conformity to the anti-doping law, and it was actually in France. It's adopted by the state, not by the sports association. With the Olympic Games of Paris 2024, there was a strong judicial pressure so that France could be in conformity, and the penalty could be a deleting of the World Agency anti-doping in France. So there was an indirect pressure on the French pub services so that it could be in conformity with the laws. It passed through the WADA, World Agency, that talked with the ministry to have a law that could be agreeing with the worldwide anti-doping law. So there's no direct law on the governments, but there's indirect possibilities to put it in action. For the French labs, it's the same thing. According to the standards on labs, the WADA standards, labs are supposed to be independent of the of the states, of the sports ministry, especially of the Olympic local committee, etc. They're supposed to be independent. If ever you have a state that integrates the lab in its own structure and makes it an attachment to the sports ministry, the penalty is not going to be against the state, but the lab could be suspended and we could take off its accreditation. Now it's a political problem. Is the WADA attentive enough? Does it really check that every lab is independent? That's another question. But once again, indirectly, through the means of the signatures, people who sign, that we can act on the government with the rules that we talked earlier, the rules that stop them from putting a competition that would happen on a state that is not respectful of the code and that is not part of the UNESCO convention. So it's kind of a norm problems through indirect action. So even though the states didn't sign the code or not bound directly by the code, there's ways to act on the behavior of the government. Cécile, to just say in a couple words, I think that there's a real schizophrenia. As you said, one of the fundamental principles pursued by the WADA and by the code, and also the European Council said the same thing, is how sports should be independent, and also agencies, anti-doping agencies should be also independent. That's nice, but who has the capacities materially of financing a lab with everything that it needs in research for anti-doping? Most labs, actually, their working plan is not viable. So at the same time, WADA is saying to the states, there should not be action of the states. You should only give the means, action of the state in there. It should be independent. But at the same time, we know that the labs cannot work only through a financial support linked mainly to the state. Then the FLD was criticized by the WADA as being non-conform. But when we compare to other states, honestly, I don't think the FLD is the authority that we should stigmatize. But especially on another side, recently, as you said, with the power of investigation of the WADA, and that it wants to put in place, because that's how we understand to have some efficient elements for the fight against doping. Well, FLD is taken as an example. Why? Because since it's a public state authority, because in other states it's association, the French government can lead it to judicial problems. The FLD has penalty problems, but the others don't have the equivalent of perquisition in private places to take documents. the WADA wants to fight because it's a state's government. That's where the schizophrenia is. We don't want the state to meddle in there, and we can understand it from the sports movement, but the efficiency of the fight depends also a little bit from the means that the states can put in. So we are in the research of that balance, and sometimes we go too much on the one side, too much on another one. And that balance is problem, which is why maybe that principal point is trying to bring in some balance. It's also a really interesting question for international jurists. We are in a question of transnational rights, national rights, public rights, etc. I invite you next May to the convention that is going to be organized by Franc on international sports rights in May 24 in Paris. But before taking a break, because I have the pressure of the leaders to have a 10-minute break between two sessions, there's a mic in the room. I think it's the opportunity for you to ask questions, to take advantage of it, to have two questions. You have to get up. It's right to our cameraman. If you have any questions, you can get up and identify. Give us your identity. If you have questions, some comments that he will answer. I invited the colleagues from the Rousseau concours to ask questions if they want. Of course, you understand that we're not going to resolve the nature of the engagements, but we're not going to find an answer. But there's a question from Mathieu Desonneuve. Differently from David and Frank, I am not internationalist by training. Maybe which is why I'm going to say something that might be weird for you. I'm not sure that there's a lot of practical interest to resolve the difficulty of knowing what means the principles stated in the code to which the states are held to because of the convention. Because as Frank said it, there's indirect ways of constraining the states to respect all the code and not only the principles, by striking to their labs, by striking their international agencies of doping, by refusing to giving them international sports events. Carus can illustrate that fact. Judicially, of course, Russia is not sanctioned, of course, but for everyone, it's Russia. Symbolically, those indirect sanctions are striking Russia. And second thing, if we really want a state to be sanctioned because it doesn't respect the code and not only the principles of the code, I think there's ways without even referring to the case, without even going to CIG. There are possibilities to sanction a state that doesn't respect the code with some simple evolutions that we could think of. For example, there's a very simple one. When the CIO grants the games to a town and not a country, for example, Paris for 2024, there's a city host contract that is signed. For example, two things should be done. Put in the contract a clause, an element saying that the city, or of course it's going to be linked, the people signing the contract are engaging themselves during the games to respect all the anti-doping code and to sign that contract not only by the town, as it's the case today, but by the states welcoming them. It wasn't possible before. The Olympic chart was modified, and the 36 rule allows today that contracts of city host can be signed by a state. For example, a state that would not respect the anti-doping law during the games would not respect the contract, and it would be therefore possible to act the other clause, for example, by taking the court, as it said in that contract, and it could be because of a contract, a state could be punished, not because of UNESCO, not because of the principles, but it would not have respected the code of anti-doping during a certain period defined by the contract. And so because of the investment rate, he's going to talk more about it, Frank, because he had talked about it for a bilateral investment in Brazil. Are there any questions? Go to the mic. Hello, everyone. Thank you, first of all, for this first part that was really rich. I would like to go back on the historical dimension that was said at the beginning of the talk. You started to answer the question, but it was deviated. Why was UNESCO chosen and not another organization? Historically, I'm sure there's a reason, especially around that time. Franck? Yeah, well, because we had to find an institution multilateral mondially, worldwide. There was not a big possibility of choices. And UNESCO had already worked on sports in 1978. There was an international sports of chart of sports, and it was the one that was best corresponding to those questions. It was the only one basically who had talked about sports. So it was kind of by default, and the UNESCO was okay to hold the convention. So that's how it worked. Thanks. Are there any other questions? So thank you for that first part. I wanted to ask, with the principal examples that you said from 2021, is there a way that the convention, the code of anti-doping could be acted retroactively? Matthew, I saw that you were ready to answer. You took the mic. In the UNESCO convention, the code is referenced, the code being adopted in 2003. So maybe is it the amendments that were adopted later? Maybe we could talk about it, but it's said in a way that it could be discussed about. Retroactively, I'm not sure I understand correctly. For example, a state that today would not respect a principle that will be adopted tomorrow? I'm going to ask a question. Do you mean that the 2021 version can apply to something that was done in 2019? Or is it we have to go back to an old version back then? It's kind of what you explained, yes. New principles that evolved with time, can we reattach them to facts that were, to events that were happened before? On that question, the code answers on it. It references one principle, and this one is named, of the soft rule, meaning that the only principles that can be applied retroactively are those that are soft for the people pursued for doping, and not those who are harder. It's at the end of the code. The question is answered at the end of the code about the things that can be applied or not back in time. Maybe there can also be that question, because in regards of the controls and tests, we have a conservation test that's 10 years now long. Of course, we know that some tests can be made 10 years later. And 10 years later, the list of substances has changed. The amount can change. And generally, we apply the list that was applied when we do the test again. And yet, when we had done the test 10 years later, that substance maybe was not forbidden back then. So there is that problem, yes, here. Real questions about the modification of the list, because we had a famous case of a tennisman who, when she was tested, that product was authorized or was not forbidden, and then when we got the results of the test, between the list had changed and it had become forbidden. So there was a battle to know which one we applied. So there can be a difficulty that are not all resolved because there's big battles that can be present. So we're going to take a break. It's 22 until 32, just 10 minutes. We have some editors outside. So there's the Pedona editions, the international rights review in Canada, in Quebec. If you want to consider the elements they have. Just 10 minutes, we go back at 32.
Parfait, merci. Alors, on va reprendre notre journée avec ce
So we're going to continue our day with our second panel.
Donc, vous avez assisté à un très bel échange.
You watched a great exchange. Now we're going to go to a more traditional model, meaning that we're going to have our three conference men who are going to present one after the other, and then we're going to have our exchange time. We are now at that panel named Doping System in Russia, a violation of the multilateral anti-doping law. So our three panelists, I'm going to present them to you. Master Richard Pound, an old Olympian in swimming. He was sixth in 1960, an old member. He presided the Canadian Olympic and founded the anti-doping agency, which he was president of. Our second conference, Jean Lévesque, professor in the history section in Montreal, director of Eurasia, and a teacher in modernization. He's a specialist in the history of Russia, published in 2022, Yves Roche, from the Alpine area, the story of Olympian Games from 1928 to today. And then we're going to welcome Cécile Achovi, a doctor and member of the political and judicial. He has a long history, taught in he also trained some jurists in the rights, world rights on anti-doping and in sports. I'm going to put the...
Thank you very much. I will be speaking in English. Good afternoon, and thank you for this invitation to speak. I apologize in advance for the risk that this might seem to be drinking water out of a fire hose, because 15 minutes is not enough time to deal with the many complex aspects leading to the various investigations into Russian doping, and in some cases leading to no investigations. By way of background, organized doping in sport began after World War II. The initial choices of substances were stimulants and testosterone-based anabolic steroids. Stimulants were principally race day drugs, whereas the anabolic steroids were taken during preparation and training periods to increase strength and to recover from training. Interestingly enough, there were no sport rules that prohibited doping. Legislation and regulation of drugs was dealt with by domestic authorities and focused essentially on what we call today recreational drugs and quality controls for drugs that were used for therapeutic purposes. It was the death of a Danish cyclist at the Rome Olympics in 1960. Those are the ones that I was in. I looked like I should have been in Melbourne, but no, I was 1960. And he died due in part to the use of stimulants. That led, as we heard this morning, the International Olympic Committee to create a medical commission and with a subcommittee on doping and biochemistry. The latter subcommittee was charged with the responsibility of preparing a list of prohibited substances. The IOC commenced testing at the Olympic Winter Games in Grenoble in 1968 and has continued to test at every Olympics since then. There was a practical and systemic problem within the international structure of organized sport, and that was that the IOC had the right to test only at its own event, that is to say the Olympic Games, thus once every 4 years. Between Olympic Games, athletes were subject to the rules of their respective international federations, which did not test the athletes, nor permit the IOC to test them. It's safe to observe that the international federations had no appetite whatsoever for drug testing, particularly by an organization that they did not control. During the Cold War, countries on both sides were delighted to use the performance of their athletes as demonstrations of the effectiveness of their particular societies, each, of course, in their own political contexts and social contexts. In Eastern Europe, doping was essentially organized and administered by the states or state agencies, particularly among the countries in the Warsaw Pact. In the West, governments were not actively involved in doping programs, but on the other hand, did nothing to prevent them, knowing full well that their athletes were competing against doped athletes. The most scientific doping outcomes, particularly were in East Germany, which had astonishing outcomes, particularly with adolescent females. But each other country also had its own programs. After the collapse of the Soviet Union, doping continued, and the Russian Federation took a more visible lead in the doping, particularly once the two Germanys were reunited. The known state of play was that Russian athletes were doping with the assistance of state authorities. Access, however, to Russia was and still is restricted. Satisfactory evidence of the doping was simply not available. The formation of the World Anti-Doping Agency in 1999, following, as we heard this morning, or earlier this afternoon rather, the 1998 Festina scandal in the Tour de France, brought about a new opportunity for an integrated set of international rules. This was reinforced by the adoption of WADA's World Anti-Doping Code in 2003, which in turn was incorporated into the internal rules of every element of the Olympic movement prior to the commencement of the Games in 2004 in Athens. That was followed, again, as we've heard, by the adoption of the UNESCO International Convention on Doping in Sport in 2005, followed by its ratification, its ratification by the state parties in 2006, pursuant to which those state parties undertook to use the code as the basis of their state anti-doping activities. Focusing on the investigation into Russian doping, there were impediments. Many international federations were reluctant to investigate doping in their own sports, even outside of Russia. And many of those federations relied very heavily on Russia to stage or support their events. Nor, frankly, was there much enthusiasm regarding an independent agency such as WADA to oversee their doping activities, or their anti-doping activities rather, or the lack thereof. This was also true of the public authorities, including Russia. A measure of all that is that although WADA was formed in 1999, it was not until 2015 that WADA was permitted by its stakeholders to conduct its own investigations. It was allowed to rely on other investigations, but it couldn't do its own. I chaired the independent commission, which was the first WADA-conducted investigation into Russian athletics in 2015. It was triggered by revelations of a Russian anti-doping official, Vitaly Stepanov, and his wife, his athlete wife, Yulia. After smuggling the Stepanovs out of Russia, ARD, a German broadcaster, televised an account of what they had discovered. It was so explosive that the Stepanovs would have been in grave personal danger had they remained in Russia. WADA decided to investigate. Our independent commission found massive corruption throughout Russian athletics, including the covering up of positive tests, declaring certain athletes coached by certain trainers to be exempt from testing, giving advance notice of out-of-competition tests, using false documentation, the active implication of the FSB, which is the successor to the legendary KGB, in the laboratories and elsewhere, providing drugs to athletes, the involvement of athletics officials in extorting money from athletes to cause positive tests to disappear, complicity of the Moscow laboratory and its director, unsupervised provision of samples, urine samples, and much more. We at WADA had a Scottish president at that stage who, in the Scottish effort to be frugal, restricted the terms of our reference of our commission to simply athletics, that's to say track and field, and not the entire Russian sport system. As a result of our report, which we published at the end of 2015, the accreditation of the Moscow laboratory was first suspended and then revoked. The lab director was discharged. The Russian anti-doping organization was suspended, and the International Athletics Federation suspended the Russian Athletics Federation, a suspension that remains in force even today. In early 2016, we referred the evidence of criminal extortion to Interpol, and the French authorities agreed to take up the matter, which resulted in criminal prosecutions and convictions against the president of the International Federation, against his son, against the chief anti-doping officer of the International Federation, the Russian treasurer of the International Athletics Federation, and the French lawyer who was involved in the extortions. On the footsteps of our investigation, in early 2016, further revelations, this time across the entire Russian sports system, emerged. The additional information, oddly enough, coming from the disgraced Moscow lab director Grigory Rodchenkov. He too had to be smuggled out of Russia before the information became public. And that information led to a second investigation, this one headed by Canadian law professor Richard McLaren, who had been a member of the commission that I had chaired earlier. He uncovered the mechanics of the cover-up system, the provision of samples to be held in storage, which could be substituted for samples provided by Russian athletes during the course of competition. How the supposed tamper-proof containers for samples could be opened and the urine in them switched for clean urine and resealed. How the samples were switched during the Sochi Games by the FSB in 2014, and very likely at the Football World Cup. Also, how computer records were manipulated, and a host of other fraudulent actions were carried out. Since the 2016 Rio Olympics were fast approaching, Professor McLaren issued an interim report of his findings. The IOC refused to act upon it, pronouncing the report to be mere allegations rather than the findings of an experienced investigator. In the end, much after all this took place, the IOC agreed with all of the conclusions of the full report, and the Russian National Olympic Committee was suspended just prior to the Pyeongchang Olympic Winter Games. Athletes who met certain conditions were allowed to compete as Olympic athletes from Russia, and the WADA imposed sanction against the whole Russian apparatus of 4 years was reduced to 2. Despite the fact that the Court of Arbitration for Sport panel, which included an arbitrator appointed by the Russians, specifically and unanimously found that the corruption could be traced to the president of the Russian Federation. A related WADA investigation was directed to the Russian computer records. WADA had obtained a pre-investigation copy of those records and sought access to the current official records to determine whether or not there had been alterations, and alterations were widely suspected. WADA also had to take possession of the samples themselves in order to be able to assert and to approve or prove anti-doping rule violations. There were many Russian-caused delays in providing both the samples and the computer records, but they were eventually and reluctantly produced after we declared their anti-doping agency once again non-compliant. After a detailed forensic audit of the computer data, it proved to be an absolute treasure trove of deliberate manipulations of the database. As a result, hundreds of doping violations have been discovered and asserted against the athletes involved. Throughout all of this, Russia has been completely unrepentant and belligerent in asserting that the whole series of matters is nothing more than a Western political plot directed against Russia. Virtually every charge is routinely denied, and resulting actions are very noisily contested. Russian officials, sport and other, refuse to acknowledge any guilt whatsoever. And then finally, of course, there's the investigation that did not take place. And there was some talk about that in the panel before. And that is the one that should have been undertaken by the public authorities in respect of the UNESCO Convention. Russia was clearly in breach of its obligations under that convention, but the state parties have refused to act. Russia's soft power is such that the other state parties are unwilling to hold it to account, which exposes a fundamental gap in the anti-doping system. Thank you.
Thanks a lot, Master Pound. We're going to continue now with Professor Lévesque, who's going to present to us a conference named Are We Facing a Resurgence of Soviet Problems of Doping? I'm kind of because I don't have the training, so I'm kind of the intruder here. I don't have the ambition to contribute to a rights convention, but I want to explain that there's a political point about this question of dopage, Russian doping. Thank you. That's better? Okay. I'm from the old school. There's a political context around that question of Russian doping, which is quite interesting to me because, as the presenter said, I'm interested to Olympic Winter Games, to its political interests, which brought me to Jeux de Sochi, on the one I'm studying right now, which brings a lot of thoughts. For example, why should we risk to put in problem soft power, 55 millions, etc., in a business that, in the end today, reduced the soft power, the Russian one, to very low, actually. They fought against a pariah status, and now they are back to a pariah status, which is kind of what we saw back then in Soviet Union, where we accepted the rules of the games. We were there. We were talking about motivation, political motivation, but we were not attacking the foundations. At the arrival point of the crisis of the doping challenge of Russia is that we are questioning the foundation of the associations who accuse us. We could talk about short power instead of soft power, a business that wants to strike, which will bring me in conclusion to have some historical parallels and see where it can bring us. Maybe I'm going to deceive some people who wanted to know more about the Soviet area, because ironically, we know more about the doping now than when we did in the Soviet area. First of all, because it's really, the information is really spare. There's a lot of scandals that appeared in the Russian press after the fall of the Soviet Union, but nothing like we know today with RDA and its army of old athletes who defected and who tried to be wealthy somewhere else. There's no work back then on the Soviet doping. We know it's there because it was admitted by high people like Sergei Gortuga, who said, I have no problem. I'm against doping for young athletes, but for older athletes who are in full consciousness of what they do, we are in the knowledge of trying to perform. So it was at the beginning of the 90s, and what I'm trying to explain, basically how we arrived there. First of all, on the Soviet area, the arrival of the Soviets in the sports at the end of the 40s, in 52, 56 Olympic Games and Winter Games, with quite high performances for a country that had not a lot of experience in international competition, raised, of course, questions. There were some allegations made, but nothing fundamental and nothing deep about it as to what we know for the RDA. For example, today we agree with specialists to say that doping of the RDA, which comes from the Soviet system, but which is quite legitimate towards the RFA and towards the big brother, led to perfection with a German precision, the practices of doping, which from the Soviets came from an interaction between the trainers, the pressure for performance, and the activities of the institutions of pharmacology, of sports, of medicine in USSR. The Moscow Games, to give you an idea, quite striking, were named the Formations Games because no athlete was recognized as doping, even though it was already happening. And the games in '84, the Goodwill Games, there was no test there. So maybe we could think the worst of it. What happened afterward, at the fall of USSR, and I'm going to be quite precise actually about the period, I'm an historian after all, there's a time of liberalization, an opening, which we can compare to the same opening we had during the connections with the replacement of Ignat Romiko by Mr. Darkozelev in 1982. During that time, of course, doping practices were massive, but the controls were almost over because the state was financing, and it was the pride of the Soviet Union. Back then, I was looking at archives and libraries, etc., with the purpose of my training. I fell upon a huge to an area that belonged to Russia, which had the possibility of selling out of taxes some alcohol, etc., to finance its activities. During that time, Robert Edelman demonstrated it, the historian, that the fall of control doesn't mean that doping practices fall too, but brings a practice which will disappear, which is that the Soviet functionaries who were looking to find a place in international institutions are now going to defend their athletes like they did back then and like they will do ever since the end of the 90s, with a certain strengthening of it. For example, Irina Prival code. Irina Prival was tested again and again. For example, we have the case also of a runner, Nadish, who had to finish, who went to compete for Norway because Russia never defended it. And before the games of Atlanta, some lift waders kind of left because Russia did not want to sustain them. But that period is kind of short. The Russians are second in the Atlantic Games, which is kind of good actually for that time without being doped. It's going to lead to some elements also, and the succession of first ministers who are going to be a little bit more firm or conservatives and partakers of a strong case like Primakov and Vladimir Putin. So during that time, the opening is going to be short compared to what we have in the 90s. We now are going to have a return or a syntax. I have a problem seeing Putin's regime a return to Soviet practices, but trying going back to what will work in old Soviet Union compared to a private finance, and then which is going to go back to a public one. There's a financial area, there's a problem. Ever since 2004, relations with the West are going to be more complicated, especially with the extension of NATO and the discussion in 2017. Gazprom, Rosneft, Ukrainians are going to be seen as heroes by sending semi-private financing to sports. Russia becomes a great sports power, going everywhere ever since 2009. In that context, the chain of events, it starts by Les Universités de Kazan, which costs millions, even though it's universal games. Of course, it's Sochi, 55 million, the most expensive. World Cup in 2018 and Formula One in Sochi, which is going to be placed in St. Petersburg. There's a will of Russia to go back, but I'm not going to repeat what was said, of course, previously, and try to bring new elements of Juridish, but there was high level doping skills. It was the fruits of what the state had done in the past, with new elements that are new. What I think, my last point, I think I have 5 minutes. Perfect. The last point I want to bring is, are we in this perspective with Sochi, with the doping, to that crisis of Russia? Are we in the soft power? Soft power for politologues, it's a concept that's Joseph Nye, which made Joseph Nye really famous in 2004 from Harvard, and then who was applied to every country, every context. It's the influence that a country can have, but that goes beyond and is different from the influence and economical pressure and military pressures. An attraction power of a state on another one that can lead it to change its habits, its decisions. Are we in it? Or are the authoritarian states such as China, who have a different strategy I don't want to go into right now? The authoritarian states are not in the same register. And what I want to demonstrate today is that, first of all, when you have the beginning of the doping crisis, the Russian answer can be seen as in the Soviet traditionalism of whataboutism. For example, answering a critic with a critic. For example, the treatment of sexual minorities in situ. So we turn the problem back to the one who asks it. We're gonna go back quickly. I'm gonna give a couple cases. For example, Putin says during the paroxysm of the crisis in 2016 before the games in Rio that there can be no support of the state in regards to doping. But the next day he says that allegations are part of a anti-Russia political element. So we send back the critics to those who sent it to us. Pushkov, Alexei, president, says it's an act of political vengeance for its politic of Elena Sinja, world champion, foreigner practice. She now says that I won my fake gold medal. I could go on and on, but in autumn 2016, you have Vitaly Mut, the president of the Ministry of Sports, who is promoted as vice minister as a defiance act. Then is going to be promoted to an anti-doping. She's for Putin, and she's going to be placed in the doping agency, anti-doping agency. So we're going to have both the attack and the return of the critic. There's not a lot of time, and I wanted to finish coherently. That's hard power, which is a bit stronger for authoritarian states, which wants to destroy the influence of countries, is going to lead us to what? First of all, in 1984, I talked to you about the Friendship Games. They were games in parallel to Los Angeles ones. You're going to understand where I'm trying to go with this. In parallel to the Olympic Games, that because of the good relationships that Gorbachev were securing with the West are going to lead to nothing, and the USSR is going to remain part of the Olympic Games. You have, just before the invasion, I'm going to give you two modern example. Just before the Pyeongchang Games in 2018, there was a logo, ROC, ROC, not ROCK, with a bear attacking and showing teeth to show that Russia was ready to fight. After the Tokyo Games in 2021, there was a campaign, hashtag We Will Rock You, athlete that had won medals in Russia who was defying the sanctions in that way. So maybe we are going to ban all the Russian athletes. Maybe there was also the invasion of Ukraine. There was also propositions there to organize, Russian propositions to organize games in parallel with China. It was repeated in March that there were going to be competitions in China this summer, and that Russian athletes would be invited like the other ones. There was African subventions to stop the banishment of Russia. So are we going to have parallel games of Russia? I doubt it, because Chinese, after reached the summit after their walk towards Olympic Games, and have now their own games, but diplomacy being what it is, they can press tactically on, I'm going to say, on the Russian defiance on international rights. Sorry, and thanks again for your attention. Thanks a lot. We're going to go now with the presentation of Mr. Roland-at, who presents his communication, which is named The Sentences of Arbitral Courts with the Doping System in Russia. Good evening, everyone. My presentation is going to be about the arbitral sentences. And I have two goals. We saw what's happened after Sochi. We saw what two main cases that was led, and then the McLaren case with 3 reports. The problem of that report was that we had a global system, but what is the consequence? If we say Russia organizes doping, we cannot sanction Russia. We saw it, the system doesn't allow it, at least technically. There are ways to do it indirectly to penalize Russia. And so through that sentence, I'm going to try to show that actually there's a possibility to confirm and therefore apply sentences to the sports organization on one side and athletes on another side, with an element special for the athletes, and that this confirmation has an effect, repressive one and dissuasive for the long-term doping of the state. We hope it's going to work. So the first category of decisions that we have are decisions that concern the sentences, arbitral sentences relative to the sports organization. The IOC, WADA, and World Agency are going to sanction the Russian sports organization. You won't be able to present athletes. The accreditation is taken away. You're going to be suspended from participating. You won't be able to name people who will be presented as candidates for the elections worldwide. And those sanctions, for most of them, have been confirmed because the tests allowed those types of sanctions institutional against the sports organization. There's an important decision from 2020 that talks about something that happens after, and that the first conference man said, which is once WADA wanted to collect the data, computer data, Russia, the lab of Russia, trafficked those data to try to change the narrative by reading the data. So here WADA put in place a procedure against the anti-doping in Russia. And the sentence says that manipulation of data is confirmed between the data that we got from the whistleblower before WADA asked for the data, and the data that anti-doping Russia gave afterwards. And therefore, the sanction, which was of 3 orders, especially institutional sanction, but also financial one, a fine against the anti-doping agency in Russia, was confirmed. So we had a possibility of sanction institutionally and disciplinary measures, which will penalize the sports organization in Russia generally. And if we discover a state doping, then we can use the same formulation. We talked about China earlier. I'm not sure if we know what happens in China. The other states, if there is a transparency nicely enough in the state, yes, we can see clearly what's happening in there, or at least clear. It's going to be difficult to say there's a state doping. Maybe some organizations, some clubs are going to dope, but not a state-organized doping as per se. So that institutional doping is an opportunity for other sports organizations if we discover a system that's in place. Second category of decisions and sanctions is the sanctions against the individuals. And here there's several problems raised. I'm going to raise 2 and show how they were treated. Can we sanction collectively all the Russian athletes? Can the collective sanctions be allowed? Can we sanction athletes without giving them the possibility individually to defend themselves, to explain what they did? That's part of the first question against the collective sanction. We can see that the decisions that were taken, especially the fact of forbidding the committee in Russia to present athletes that were previously sanctioned for doping questions, the court is going to say it's not correct, the arbitral court, because the collective sentences are not possible, but the institutional ones are collective, indirect ones. If we sanction all the Russian athletes without making the sanction individual and seeing what each of them would do, it would be contrary to the human rights, to the presumption of innocence, and the rights to appeal. But especially for the case of athletes that were able to be sanctioned for doping and that we originally exclude, the arbitral courts said that it's a fight of a double sanction. So there's double sanction done without there being a procedure justifying that sanction. That problem actually was present before when that rule was put in place to sanction the state doping in Russia. We were not original. We took a rule that was already existing, known as the Osaka rule, because it was put in place in Osaka. And the court is going to say, even in the case of the principle that existed before for athleticism, yes, we already have jurisprudence who broke it. In that case, what we do today to ensure and sanction state doping in Russia is contrary to the rights and the Olympic chart. In my opinion, there was a formulation error. Because if we talk about the Olympic chart specifically, the International Olympic Committee has the possibility to exclude athletes without any justification. If the committee excluded athletes without trying to justify, maybe there would not have been that many problems as saying we exclude them because they were sanctions before for doping. To conclude, what the inquiries showed, those inquiries that were kind of general, with reports that were not very specific, except the second one, the second McLaren report, those sanctions, those procedures are going to confirm what we discovered through the inquiries. The state doping in Russia is not a doubt anymore now, and the consequences are also confirmed, especially in the institutional consequences for the organized sports organization. And for the athletes, we're going to see case by case. If an athlete can say he didn't prove he didn't do anything, and that its penalization has a bad element on him, he can prove it. So I didn't talk about it because it wasn't part of the topic directly, but it comes from the first presentation. The inquiry is also allowed to proceed to an adjustment of all the different elements. We realize that there's complicity, institutional complicity internationally, and we're able to take measures against those who are implied and break off the corrupted system in the international field, with the possibility of a penal follow-up in France. I'm going to continue by saying that doping, we talk about it as mainly coming from the sports movement, but there are many states that consider doping as criminal and that use their penal rights to sanction the doping questions. So there are problems that are present long-term, and I will stop here. Thank you. Thanks a lot to all three of you for your interventions. I think we have about 10 minutes for question and answers. Who's going to ask the question first? The mic is there. Vincent Frenette, University of Montreal. Thank you for your comments. I think we're good. The question that I have concerns Francophone Act. I realized that it seems that they have political desires. I want to know if you know if regarding the international right, was it in the thoughts or was it really only political considerations to be able to sanction indirectly the anti-doping system, the doping system rather, in Russia? Someone wants to answer? I cannot offer answers. I didn't look at the discussions in Congress to arrive there. So I'm going to make an answer on the basis of what I have of the American system. The USA don't really follow the European, international rights. So they have Rodchenko is a refugee in the United States. They have they're against Russia. So I would say it's mainly political. Are there any implications in the international right? Yes, there are implications there, because this legislation will allow an extraterritorial for the American system. I practice the sports rights in the room, so I don't have an academic answer. But what America does, what the USA do, every single country that criminalizes doping says that that's the same thing. There's, for example, a Tour de France, or where some athletes, Italians, Brazilians, are going to come. If they are found for doping, they can be
mais
pursued,
ils sont sur le territoire français.
but they are on the French
Il n'y a
territory.
pas autant
There's
d'extraterritorialité
not
que ce que les
as
Américains
much
font.
extra
Les Américains corrigent en
territorialism
disant,
as Americans
dès
do.
lors qu'il y a des
Americans correct
athlètes
saying
américains
as
qui
long as there are
participent
American
et
athletes
qu'il y a
that
plus de deux,
participate
je crois,
and
deux
there's
ou
more
trois
than
Olympiques.
2 or
Donc,
3, I think,
cette
in there.
extraterritorialité
So that's
existe. Si les États
extra
n'en veulent pas, qu'ils
territorialism.
coopèrent à
If
un
states
régime
don't
plus
want,
contraignant. Sinon,
then
l'État puissant va
the sovereign
instaurer
state is going to
son
instaure his
pour
regime
des raisons qu'on pourra
for reasons
difficilement
that we can
détecter parce que tout
hardly
ne se sait pas.
detect because everything's not going to be said.
Bonjour, Danielle, professeur à l'Université de Montréal.
Danielle, a professor at the University of Montreal. I want to take advantage of that tribune to maybe think that some rules that were talked about in terms of doping and sports and judicial rules are because of political fights or imminent. I think that we have the chance today of having a fighting person in Michel Pound. Are there any rules today? If there are, it's because we owe him a lot to the fight of Pound because of for the Olympic and federations, for the states, end up accepting to adopt.
So, Richard, I have a question for you because I think you might be able to tell us how difficult it was, or maybe still is, to make sure there are some rules and they're applied, and what kind of pressure, what kind of maybe even intimidation you were subject to, or people that wanted, or organizations that wanted to make these rules and have them implemented. Could you share something with us about how difficult it has been or might continue to be? We have all these young people here at the Concours Rousseau that might learn a lot on how these legal rules came to exist because of battles made by people, real people.
Well, that's a question that would take some time to answer. But starting off in the creation of what became WADA, what we faced was a very difficult group of stakeholders. International federations are individual fiefdoms. They talk about autonomy all the time. And so they didn't want an independent organization looking after them. Lots of the countries with state programs, and there are many, Russia's not the only one, have no interest in somebody looking over their shoulders. National Olympic committees are, under pressure at home to produce results and all that sort of thing. So we had to go very, very slowly in getting consensus to create WADA. And then when we started that, it was very interesting. All of the federations say, my sport is clean. Your sport may not be, but mine is clean. And when we got into the field, starting in the 2000, to test before the Sydney Games, we found that, and we just looked at the summer federations, we found that something like 18 or 19 of those federations did not even have rules that allowed them to test their athletes out of competition. So all of a sudden you say, this is talking the talk, but it's not walking the walk. And so incrementally, we've reviewed the code every 4 years or something like that to make it tighter and also to take away our stakeholders. When we started off with WADA, believe it or not, we could find and assert an anti-doping rule violation, but we couldn't prosecute it. We had to depend on an international federation or a country to take action on its own. And of course, there was no appetite for that. So we now have a process that and our friend here will know, we can assert an anti-doping rule violation and the proposed consequences. The person or organization involved can accept it, end of story, or they reject it. It goes directly to the Court of Arbitrations for Sport. You don't need a reluctant international federation to take an action against, maybe a Russian athlete that where there's lots of other pressures. But so it was a very much an experimental work in progress. I think we're getting better and better at it now, and we have a certain level of confidence generated in the sports system as a whole. Our real problem is the one that I mentioned, closing off my earlier remarks, is the countries have no interest in taking on other countries. They don't care about the sport. They care about the international relationships, and they're much deeper than sport. So it's you got the sport community is pretty good. We know who the athletes are. We know where they are. We know who the good coaches are. We know who the bad coaches are. But we don't have the power to go in and seize evidence and do all of those acts that the state parties can do. And so it's been I think if I were David Pavot, I would have one of his students go through the minutes of all the WADA meetings dealing with what are ways that we can make the fight against doping better, and see how many, I suspect it's 0, of the ideas came from state parties.
Thank you so much for that answer. The organizer tells me that our question and answer session is finished. This closes our second panel. We are going to start in 15 minutes again, if I'm not wrong. We're going to have a break and we're going to continue in 15 minutes. Thank you. An American law, Rodchenkov, Anti-Doping Act. And to talk about it, we have the chance of having a panel of people here. I want to say all the panels were amazing, and it continues right now because we have online Travis Steigart, who's the general director of the agency Anti-Doping America, and who was one of the main people at the origin of the adoption of this law. Travis Steigart is not unknown in the anti-doping sports area because he was involved from a long time ago, a lawyer by function. He worked on allowing Lance Armstrong to fall to show that he was a doped athlete. Then we'll have one of our colleagues who comes on the other side of the border, Geneviève Biren, who's a teacher at the State University of New York, and Cortland campus, professor of rights, and who wrote one of the first articles on the Rodchenkov in Anti-Doping Act, and on the capacity of duplication and modularization that could be that law in terms of anti-doping fights in sports. And finally, we're going to come out maybe of the American laws or modelization to come back on the international rights with Thibaut Fleury-Glave, professor at the University of Versailles Saint-Quentin. Thibaut is here as an expert of extraterritoriality and international rights. We know that the questions of extraterritoriality anti-doping acts were at the center of some critics by the Olympic Agency and the Anti-Doping Agency, critics also in the doctrine itself, from some authors who were afraid of that extraterritoriality. That Anti-Doping Act is relevant today, but also was also relevant yesterday. I hope that you followed what happened in the States with the accusation of Eric Lira, which kind of changed the Geneviève conference. But without waiting, I know that he's online, so we're going to begin with Travis Taggart. Travis Taggart, who's going to present to us the beginning of that Anti-Doping Act.
We've met in Lausanne last year at the WADA Symposium, and I'm really glad you have accepted to
Hey everybody,
share your
David,
time
thank you for that overly kind introduction. Once I figured out how to hit the translation button and understand what you were saying, I heard a few nice things, so thank you. I'm not sure what was said about the Lance Armstrong case prior to me figuring out the translation button, but I'll assume that was complimentary as well. You know, in all seriousness, it's really great to be here. And before I say anything, I think we're supposed to screen share maybe for my presentation.
Maybe you can share your slides. You get the master, and you can share your slides by yourself.
Yeah. Do I need to share screen? Oh, here we go. All right, perfect. So hopefully you all can see.
We can see.
You see that? All right, how about now? David, we good?
Yeah.
Okay, perfect. Sorry about that. So listen, thanks for the invitation to be here. I know I have just a few minutes, so I'll probably dive right into it, but I'm really honored to have the opportunity to be here. David and I had a brief conversation in the lobby of our hotel at the World Conference in Lausanne, Switzerland, not this past March, but the year before in June of 2022, and I think we had a really good, robust discussion. He had just presented to the INATO workshop on the Valieva case. And it was a fascinating conversation. So David, I really appreciate the opportunity to be here. And of course, you know, sharing the stage with two esteemed people, and Geneviève and Thibault, and the work that they've done. Really just am grateful for the opportunity to be here. You know, with that, I am going to jump right in, and without, you know, taking up too much time, I wanted to kind of give you what David asked in the title, the genesis of the Rodchenkov Act. And my guess is, particularly given the international forum that this is the extraterritorial jurisdiction piece of this will be a large part of the conversation. And I think, you know, while the overarching theme of this session was something to the effect of unilateralism of the Rodchenkov Act or something to that effect, I don't have it in front of me. I think what's really important, and it's why I boiled it down to, you know, the famous quote from Jerry Maguire. I'm sure all sports fans out there have seen that movie, but it showed me the money, because I think it is a mutual interaction that is when the Rodchenkov Act applies. And it's only when U.S. money via a couple different mechanisms is involved, does the law itself follow the money and thus, you know, aim to protect the investment that's there. So very quickly, I think the assumption that we all should have is that sport wants to be autonomous. You hear that comment regularly, particularly in today's climate with the debate amongst the governments and the IOC of whether or not Russia and Belarus should be allowed to compete in the upcoming Olympic Games. But bottom line, and again, I'm not going to go through all the proof necessary for this, but I think it's fair to say that sport wants to be autonomous, and they want to, you know, govern themselves and make the decisions on all issues themselves. And I think that's perfectly fine in other contexts. Where we see that become a real issue is on the enforcement side of what sport attempts sometimes to do by itself, and particularly anti-doping. I mean, I would suggest safe sport is another area where there's just an inherent, in our opinion, conflict of interest by the interests of sport are sometimes, not always, but are sometimes, you know, directly contrary, if not heavily influenced, close to being directly contrary to what the demands of an independent enforcement regime might otherwise require. And so I think it's only fair to keep those issues in mind. And I don't for a second want to conflate sort of, you know, sports people that, aren't interested in integrity or anti-doping, because that's not the case at all. I think you clearly have, as a board member of, let's say, the World Anti-Doping Agency or an IF, you clearly have fiduciary relationships and requirements that each organization that for which you wear a hat demands of you. The issue for us is when those fiduciary relationships are conflicted, because the demands of the organization, i.e. your IF, for example, or National Federation, for example, if it's in the NATO context, is to raise revenue, put members in place, grow the sport. And sometimes when you have to, take away 7 tours de France, for example, that's not a very good day for the financial stability or outcome for a particular sport. So, having lived and seen that conflict firsthand, we can't really understate how difficult that conflict is to resolve if you have multiple duties and you're trying to honor both of those duties, or if it's more than 2 duties. So very quickly, we see really going back, I think, to the Armstrong case, the first time a group of individuals conspire, maybe in our, since the existence of the World Anti-Doping Agency, at least some 99 or 2000 here in the United States, when the WADA code went into effect. But you see people sometimes outside of sport laws or sport rules who aren't covered by jurisdiction of sport, who are conspiring at a very sophisticated level to both raise money and profit from sport success, taking out insurance contracts for multiple winnings, gaining significant global recognition, sponsorships, TV broadcasts, the whole deal, in order to raise money. So we saw that, and admittedly, we saw a number of individuals who escaped the sport anti-doping rules that otherwise should have been held responsible. Of course, the FIFA case brought the attention of these issues like never before, how certain, sport operators, stand in a place outside of necessarily sport rules, and kind of in this never land where whose laws are going to apply when it comes time to bribery or corruption. Here, thankfully, and similar, extraterritorial jurisdiction was found, because a lot of the bribery and corruption, the Bank and Wire Fraud Acts were utilized where U.S. funds or the U.S. banking system was implicated, even if those underlying crimes weren't necessarily done on U.S. territory. You know these stories, and again, these are all kind of in succession. The IWF, again, president, taking bribes, covering up tests for Russians and others, allowing them to compete in international events that companies from around the world had sponsored as well as broadcasted. Of course, you've got Lamai Diak from World Athletics, what used to be the IAAF, prosecuted, convicted in Paris, similarly for taking bribes, covering up tests, again, having athletes who never should have, by the rules of the sport, the WADA code, never should have been competing in those international competitions. Here most recently, I think a week or 2 ago, indictments out of Norway on the head of the IBU. Again, you see the headlines, but hunting trips, BMWs, etc., being provided to, essentially allow athletes, in violation of the sport rules, allow athletes who shouldn't have been allowed to compete, thereby defrauding the sports world. Of course, it would be, remiss of me not to mention the Russia situation, because I think at the end of the day, the Rodchenkov Act is named after Grigory Rodchenkov. He came forward, provided evidence, obviously through both the McLaren report, number 1 and 2, and then ongoing CAS cases, has also interacted with our Congress and gave the real inside story about what was going on there. One other point, and this is an email, and I'm going to pull out a portion of this email, but just so you see it, to Craig Reedy from one of the Russian whistleblowers. And I haven't pulled it all out, but if you just look at the box that I have pulled out, you'll see, this Russian whistleblower is saying, hey, we ought to have zero tolerance for those in the sports system, institutionalized, and sport around the world is institutionalized from the government. It's government funds. It falls under a branch of the minister's office. Here in the United States, it's not like that. our U.S. Olympic and Paralympic Committee does not get any private funding. We don't have a sports minister. It's all private, although our Olympic Committee is set up as a federal corporation. But around the world, that's a different case. You then see the question of a specific individual who was the deputy sports minister in Russia, who's been convicted now of orchestrating one of the largest, state-sponsored doping schemes that the world has ever seen. Thousands, 1,000 positive or, suspicious tests, hundreds of athletes around the world, many events going back to the 2012 Olympic Games to 2024, 2016 have been, ruined in large part. Athletes robbed because of the actions of Nagornik. And here, the Russian whistleblower again asks the president of the World Anti-Doping Agency, are you going to do anything about this? And the response, and this is from Craig Reedy, as you see at the time, but they said we don't have jurisdiction over Nagornik. And there was a promise for the code to have jurisdiction over Nagornik and other similarly situated people. And that draft provision was in the code in every version that came out in the last code consultation process. And it had a clear provision that would have covered the Nagorniks of the world. But at the very last minute, at an executive committee meeting in Japan and Tokyo in 2019, literally a month or 6 weeks before the Katowice World Conference, where the code was going to be adopted, that provision got pulled from the code. If you go and listen to my remarks at that conference in 2019 in Katowice, Poland, you will hear me directly state what a terrible, outcome that was for sport, in large part because we know there are people like Nagornik and others that hang outside of the sports system that will dope and conspire to dope and send athletes to games to dope and defraud other competitors, as well as, and I'm going to skip that just for time, defraud other competitors. So at the end of the day, and frankly, that was a massive reason why Congress got the impetus behind their effort to pass the Rodchenkov Act. While it was introduced in the Helsinki Commission in 2018 around the World Cup, it had not yet fully made its way, to be unanimously agreed to, unopposed in the Senate and unanimous out of committee in the House. But a new act was passed. And here's the language. Hopefully you've all had a chance to look at it. The key language, international sports doping, is now codified in the U.S. criminal code. And it's those that carry out knowingly. So there's an intent element, obviously criminal statute, to conspire using a prohibited substance or method, any major international sports competition. The key elements are 1 or more U.S. athlete, 3 or more foreign athletes are at the competition. And this is where show me the money, right? So U.S. money from a U.S. company has to sponsor the event or the organizer of the event. So if there's a national championship in Russia and there are no U.S. companies that sponsor that championship, this law does not apply. It's fundamental to the application of this law that U.S. money be involved as a sponsorship dollar or as a broadcast dollar. And then lastly, the WADA code has to apply. So all it is really doing is adding a layer of criminality for those that conspire to dope athletes, where the rules sometimes might cover them, but frequently, like Mr. Nagornik, frequently do not cover them. And again, I can't stress enough, the foundation of the law and the policy standpoint is because the investment of the money. And if the money is not invested in the event, the law therefore does not apply. And this is not unlike some other acts in the United States, the Foreign Corrupt Practices Act, the Travel Act. There are other areas where U.S. statute and legislature has gone and done similar things from an extraterritorial standpoint. So you see penalties up to 10 years, restitution, whistleblower protection, and then sharing between agencies, USADA, et cetera. And hopefully you saw yesterday, the timing of this conference was pretty good. Yesterday was the first plea of someone the first indictment under the act, Lira, who, yes, was outside of sports jurisdiction, never was a coach, never was an official doctor, was just one of these people that operated, but dope directly athletes. And importantly, athletes are exempt from any crimes under this statute. So it's not criminalizing the athlete's behavior, but obviously the sharing allows for the information and the evidence to be obtained and then handled appropriately through our process. So a couple cases that have flowed from it, excuse me. Last thing I'll say is, look, I don't know. I'm not a Chinese international law expert, but here is a glimpse of a law that this was pulled right from the Chinata annual report. But you see a discussion about major domestic or international competitions around criminalizing behavior there. So, what the hope was, not unlike other acts, the Sergei Magnitsky Act that was passed in the United States, was that other countries who were similarly interested in clean sport also pass laws that would protect their investment in sport in similar ways that the Rodchenkov Act did. And then last point, obviously the international cooperation is incredibly important. Here's a group of NATOs and others that we cooperate with on a regular basis. In the event we get information from a law enforcement investigation, like under the Rodchenkov Act, obviously we're going to share that with and it deals with athletes. We're going to share that with our partner NATOs and allow them and expect them to bring discipline against the athletes who may violate those rules. So that was it in a really quick nutshell. But again, I think my time is up. But David, I appreciate the opportunity. I'm going to stand by. I do have to head to the airport, so hopefully I'll be able to hang on at least in the car on the way up there. So thanks, David.
Thank you very much, Travis, for your time. It was very, very interesting to have your perspective on Rodchenkov Anti-Doping Act. And right now, we'll give the floor to Professor Geneviève Biran. So, Geneviève.
Can you hear me? Oh, you can. Okay, good. So I had slides, and things have happened since I made them, so they're no longer being used. Conveniently, many of my colleagues today have covered half of what I was going to cover as well. So I'm going to recap a few things, elaborate on a few things, and then get into a couple new things. I was going to give you a once-over of what the Rodchenkov Act covers and its penalties, but you just had that done. I will add that there's also the penalty for non-individuals. Individuals can get 10 years in prison, $250,000 fines. Non-individuals, so organizations, can receive up to $1 million fines. So little added feature. But it also allows the act to target organizations and not just the individuals who may be involved. So, having skipped through what would have been my first two slides quite quickly, the Rodchenkov Act, I don't want to go into too much extraterritorial jurisdiction because we have that coming up next, but it ultimately requires cooperation. That is really the input, like, to make it work. We require cooperation between the FBI, which has recently created, the Federal Bureau of Investigation, has recently created an Integrity in Sport and Gaming initiative that is focused on sport, not just doping, but that seems to be the primary focus. In theory, it could be other forms of match fixing like gambling and things of that nature as well. And that was created in 2021, 2021, summer of 2021, after the RADA Act was passed. And that is the FBI group that's sort of focusing on the enforcement of the Rodchenkov Act. But they need cooperation. And they need cooperation from WADA, from USADA and other national doping organizations, from international federations, from all of the various people that Mr. Tiger just listed and organizations. Has to happen. And both Mr. Pound and Mr. Tiger mentioned the IAF investigation, what's now World Athletics, but at the time IAF, and the Lemon-Diac investigation. And for those of you who are unfamiliar, the WADA essentially raided, for lack of a better term, in 2015, the Monaco offices of what was then the IAAF. And after what they found, which indicated evidence of money laundering and other corruption behaviors that had a connection to France, they contacted Interpol and turned that material over to Interpol and the French authorities, ultimately leading to a 2020 finding of guilt. Some jail sentences have been served, some have not. Diak's son has, for example, has been found guilty in abstention, but is still in Senegal and probably won't be leaving. So that's the type of cooperation that the RADA Act requires in order to be able to function outside of US borders. And the question really becomes if we're gonna get that type of cooperation given the international response to the act. I had debated it. It had taken it off of my slide on whether or not to read you, but I think I will. WADA's initial response to the act, but as I have a little bit of time, I'm going to. We join other stakeholders around the globe in asking why this US legislation, which purports to protect athletes and claims jurisdiction overseas, specifically excludes the hugely popular and influential professional and college leagues. Nearly 500,000 athletes compete in US college sports and thousands more in the professional leagues. These leagues were originally included in the act, but were subsequently removed without explanation. Why are those who surround the athletes in these associations and leagues now exempt from the scope of this legislation? If it is not good enough for American sports, why is it being imposed on the rest of the world? That's a good question. In the sense that it doesn't apply to our sports. The criteria, and what makes it not apply, going through the three criteria for the law, is the WADA code must apply to the event occurring, and the WADA code does not apply to US collegiate and professional leagues. Our leagues have not signed on to the code and they do not abide by it. Their doping is dealt with through the collective bargaining process for professional leagues. There are some legal reasons for this, like it's not quite as simple as just, we're gonna tell you you have to follow it, legally speaking. And the US college sports is just its own animal on how it's run. So this creates a challenge on whether or not we're gonna get the cooperation we need in order to enforce this law. And I personally would argue that we're probably not gonna get the cooperation to the level that we would like, at least not anytime soon. There are other criminal laws about sports and sport doping throughout the world. Prior to 2014, 23 of the then 29 members of the EU had some laws about the trade and distribution of doping paraphernalia and criminalized it. So there was some criminalization happening prior to this law. Germany had then passed its own law related to trade and distribution in 2016. And then I was going to mention, but Mr. Tiger beat me to it, that China strengthened its criminal laws just after the RADA Act, also covering not athletes, but those who surround them. So very similar to the RADA Act, which begs the question about whether or not this law ultimately will result in many convictions. And we'll go into the fact there's been one now, as of yesterday. But whether it will result in many convictions or whether it will serve as more of a deterrent and a model. WADA has been supportive in the past of criminal laws related to sports doping, but generally when they're focused within the country. Right now, the first RADA conviction pled guilty yesterday. So new thing, hence not using my slides. So to give you a little bit of background for those of you who are unfamiliar with the case, his name is Eric Lira. He was from Texas, so an American citizen living in the United States. He was arrested. He was a self-proclaimed kinesiologist and neuropath. He was arrested in January of 2020, pled innocent initially in March of 2022, pled innocent in March of 22, and as of yesterday has now pled guilty. We do not yet know the terms of his plea, what his penalty, any criminal, any jail sentence will be. That remains at this moment unknown to me. What is interesting, and now moot, but I'm still going to mention, is that up until yesterday, when he pled guilty, his side was making the argument that the Rodchenkov Act was unconstitutional under the United States Constitution. And this goes back to what my colleagues in the very first panel mentioned about private entities, international private organizations dictating, what governments can do. And this was the claim being made by Lira's attorneys, was that the law was unconstitutional because it improperly relied on rules created by the UN and WADA, and essentially was allowing private international organizations to dictate United States law and United States criminal law and penalty. So as those rules change, so our law changes. How can that was the challenge, and that it's too vague and too broad, and thus doesn't actually meet constitutional requirement. Now that he has pled guilty, this argument is just out there. We don't know what's going to happen. We don't know where that's going to go because it's not going to continue through the court. It's done for him. The next one, we will see if this argument gets revived, but it really remains to be seen. So will ultimately the Rodchenkov Act find itself with constitutional challenge within the United States? Possibly, but it will take another case for that to be what happens. But this first case has started to lay the groundwork of that potential constitutional challenge within the United States. Also mentioned by Mr. Tiger, but one thing I wanted to go into more detail was the Foreign Corrupt Practices Act. So as I mentioned, deterrent is one of the options that the Rodchenkov Act could actually be fairly successful. Not necessarily because it will result in a great many criminal prosecutions, but because it will serve as a deterrent. And one such law we in the United States has is the Foreign Corrupt Practices Act. It is an anti-bribery law with extraterritorial criminal jurisdiction, very similar to the Rodchenkov Act. It almost never results in criminal prosecutions. It very, very rarely results in criminal prosecution. But it is cited by many multinational corporations as an impetus for their anti-bribery compliance. So the fear of what that could come under the law results in compliance with it. It has also served as a model for laws, similar laws in other countries, as it appears perhaps the RADA Act has done in China. Remains to be seen if that continues going forward. So an example of a law that we have that serves this type of purpose, and is that what the RADA Act will ultimately be? Will it be a model and an example of what others may choose to do? Because if enough countries start doing it, then that might actually serve to be a fairly effective deterrent. I do want to be clear about the one conviction. The two athletes involved were not American. He was in contact with a Nigerian runner and who herself is currently under an 11-year ban. So she has also, the investigation into her positive tests and stuff as part of what was involved. And a Swiss athlete as well that less is known about. So both of the athletes he was working with and communicating with were not American athletes, but he himself was on American soil. So we didn't need entirely the extraterritorial aspect of this law in this particular case. There have been other charges of foreign nationals. This is not unique. In 2018, the US charged 7 GRU officers for hacking, wire fraud, money laundering, identity theft. GRU would be the Chief Intelligence Office of Russia. In Germany in 2020, one of those same 7 the US charged was charged with breaching the German parliament website. In 2021, Sweden blamed them for GRU for hacking the Swedish Sport Confederation, but concluded it did not have any authority to bring charges under their existing law. So the rationale, and I will kind of close with this, the question asked at the end of the last panel about where this law came from and kind of what the impetus behind it was, I brought my notes with me in the form of my own article, was that the Rodchenkov Act was created as a response to the hearings generally of the Helsinki Commission in order to, quote, fill an important gap with regard to US law enforcement, serve as a deterrent to those considering engaging in doping fraud, and provide a portal to gain visibility into a wider net of international corrupt practices that are connected to doping fraud. So this law is in many ways strives to seek broader goals than just let's get some trainers and some neuropaths who might be funneling certain types of performance enhancing drugs to specific athletes, but to try to get at the broader conspiracies, for lack of a better term, that goes on involving it. How much it will ultimately be successful, we have one case. I don't know. We'll see where that case, well, not that case, but future cases go. We'll see where future challenges to the law go under our own constitution in the United States. We may prove to be the biggest barrier to it in some ways, would be our own legal system. And we'll see what others do. If this starts to look like something that is potentially effective, will other countries begin to model on it and use it? And will it serve as an actual deterrent? It'll be interesting to see where it goes. And yeah, I had a lot of changes in the last 48 hours to what I was gonna say. I'm good.
Thank you very much, Geneviève. Maintenant, nous allons.
Now we're going to go to the French language and let Thibaut Fleuriri, who's going to tell us about the question raised about extraterritorial elements of the Rodchenkov law. I'll let you speak for about 15 minutes.
Merci beaucoup, cher David. Merci pour,
Thanks, David. Thanks for the invitation. Going back to the French language again and the international law to talk about that extraterritorial element of the Rodchenkov Act. Maybe by talking about that those extraterritorial elements of the American law, such as other elements, are recurrent questions in the judicial debate for a couple of years. It's quite old, actually. There was the FCPA that's from the 70s, I believe. And then we had, to quote about American laws, we had the Ellsbergen laws, the Kennedy laws, the FACTA in 2010. That kind of brought kind of noticed application with sentences, not penal or sanctions, but civil and financial penals against multinational, French among them, who had thousands of dollars of fines to because they went against the embargo that those laws had. But this extraterritoriality was also developed more recently by the Cloud Act in 2018, and more recently by the Rodchenkov Act, but also by other legislation as EU, for example, to talk about one case, the RGPD, about the protection of data, which has an extraterritorial it's quite an important element here that presents questions. There's one that the Rodchenkov Act doesn't pose, is that it has a very clear and extraterritorial pretension. It's not always the case for all of them. For some in the courts of America, the judge has to see if there was a purpose for the law to be acted outside of the country. But here, in that law, there is an extraterritorial jurisdiction in the application of that law. It's quite clear. And that's what's led to more reactions, critical reactions from many institutions, the Anti-Doping Association, more agency, also the French or British agency, who deplored the multilateralism that should exist in 2005 convention. The question that interests me today, that I was trusted with, was whether or not such a disposition or a pretension of extraterritorialism can be considered correct in terms of international rights generally. More precisely, it's about knowing about the rules of international rights, that are main rules. A state can pretend to apply a rule for facts that are going to happen in the foreign country, whether foreign people are victims or culprits. Every time I always talk about the Lotus case, I'm not going to say it, but then I say it. If I don't talk about it, I'm going to have a question about it later, so now I'm going to talk about it. The states, can they have an international right? The pretension of people, facts, etc., of things happening outside the territory. I have a problem. It's that this question is quite important in the case presented in the Concours Rousseau. And I was asked also to be a judge on the Concours Rousseau. I'm not going to ask the question, actually. If you want to go ahead, go. I'm not going to answer to it because I don't want you to be, as you said yesterday during the session, we know that this law, because the law, Céline, is inspired, not the same, but inspired from the Rochinov Act. I've been talking for 4 minutes. I'm going to continue to talk. What I offer to do actually is to try to explain a little bit the elements that are important to me to answer to that question. How the articulation of those elements is important to answer to that element, and let you think for the next days those elements. It's concepts of international rights that are specially used. So it's not going to be easy to resume them in 10 minutes, but I'm going to try giving you what seems to me fundamental. And to see in the Rodchenkov Act what can echo those different principles. When we talk about extraterritoriality, and I think that all those concepts are used without being defined sometimes and often confounded. I think there's five main concepts that we have to mobilize. We have to articulate those different concepts. It's power concepts, title concepts, competence, skills, attachment, and opposability. It's concepts that are theoretical and quite large, but I'm going to try to talk about the power concept. We have to hear by it that it's something that's quite material, the power that the state has constitutionally, effectively, if we want to do something. And often we consider that the state has three powers, three possibilities: judicial, the power to make laws, the power to judge of the application, and the power to execute them if needed by strength. Judicial, executive power, very classical. The international right places a framework for the exercise of those powers. He forces the state to write that faculty, not material, not physical, but material, to write laws, in a framework that will allow to say that it's competent, skillful, that has another element. The state is sometimes skillful, sometimes not, to put in place its judicial power. To know if the state is skillful, competent, the title needs a state. The state needs a title, sorry. For example, what is the Rodchenkov Act? From that element, the international rights are known. There's no real debate about those questions. It's the territorial state, meaning the state is competent when we can add a title, person to its territory, the personal title. Same for the skill of the state to act towards people that we can attach to its own. And then third element that is generally identified, third title, but we could add other ones. I'm going to go to the main ones. Its fundamental ideas are at play. We have the three elements where state can deploy its power: territory, person, and interest. Where things get difficult is the question of attachment. And often, the distinction is not very well made between that question of title and that element of attachment. The attachment is what will allow to say whether a situation, person of good is attached, is connected to the state, whether territory, person, or interest-wise. Therefore, we have to determine whether or not a situation is connected in a way or another to the territorial elements, a fundamental element or personal element. Sometimes it's easy. I am here localized in Canada. There's no doubt about it. So I'm attached to the territorial element of Canada. Canada can have a pretension to fix my situation one way or another. If I commit a crime, which I don't wish for myself in the next days, Canada can, because of international rights, apply his penal right to that situation. Same way, the nationality is a criteria of a connection that is quite classical, easy to identify. Once again, I am a French nationality, and the same way, if I commit a crime, a penal infraction, France, because of its personal active skills, can pretend to apply the right, its penal rights. But of course, those are the simplest elements, the most objective elements. There are many more situations in which the localization question or the attachment would be actually quite challenging and could be up to several interpretations, especially that where we can see it the most is in terms of data. Try to find the data. Microsoft in front of the Supreme Court shows it quite well. It's not difficult. It's that we could say one thing and the other one. Locate a data, it could be on a server, on the state, or you could say that because it's accessible on the state, it's also located on that territory. And actually, those connection elements are quite, it's hard to give them an objective list for two reasons at least. One, we are in international right. We are in a system in which there's no interpret that can impose that qualification judicially, saying that that situation is connected to that country, whether it's personally or because of its territory. Of course, the justice and courts are coming in, but they don't have the same element as Supreme Court or Council of State in France.
leur action annulée par la Cour suprême. Et puis,
they could be they could have that element and come in, but second problem here, that question of connection is a question of judicial qualification. Depends on the situation. Each situation, the question is asked again. What's really hard or maybe impossible is to have a list of the connection links where the fights of extraterritoriality are present, which is why you have very varied connections. Last concept, which I think is important to mobilize here, the concept of opposability. In reality, if we want to talk about extraterritoriality in a way that is at the limit of judicial, we have to talk about not only about the laity element, we can discuss about it, of course, but in the way of the measure of the reasonability, as we say in America, of the reasonability of the pretension, extraterritorial pretension. In America, that term is often used, taken into account of the committee, meaning taking into account the other states in that pretension of extraterritoriality. The other states that are facing that pretension, do they consider that that pretension is correctly opposed to them? Or do they consider that it's out of measure and that they refuse it, therefore? So this is the food for thought that I leave you right now for the plea. In reality, I'm going to say this. I hesitate when I think about that. I think it's not very difficult in terms of Rodchenkov Act. I'm not going to say it another way. It's not very difficult. When we look at the text in itself, we can see that we can consider, on one side, be careful, there's another side, but there is a territorial and personal state. We saw it, we said it. On one side, there's an application of the Rodchenkov Act when there's at least one American athlete present. We can consider that it's a personal title. We can discuss about it, of course, because we could oppose to that the argument that you were raising, saying that if the worry is that why should we exclude if the Americans should not be taken away from that doping? Why should the other ones, why should it not be include the university teams? There's also a territorial element because the competition, to simplify it, has to be sponsored by a business having an economic action in America, a diffusion rights being sent. But this is the typical element of the discussion on what is an attachment connection point. Because what does it mean to have an economical activity? And this is the same debate about the dollar use of dollar, which attaches everything to the United States, which is a discussion on extraterritoriality. Some are going to say that when two foreign states make a transaction in USA, there's no link with America. Some are going to say that the opposite, there are compensation actions, which makes it somehow transiting through the US land. So you see, things are all about interpretation. And up to now, and it's quite revelatory actually, the Justice Tribunal Court International was not taken to discuss that extraterritorial point, to talk about another point also, of a state, for example, never directly. Also, two words to conclude. First of all, that extraterritorial pretension is not much before it's not effectively applied.
Pour que le Rodchenkov Act
But
soit
for the
effectivement
Rodchenkov Act to be applied,
la coopération internationale,
cooperation, international cooperation is absolutely necessary. The USA cannot judge a person on the territory if somehow that person is not approached by foreigners if that person is away. FBI, of course, can work with foreign agencies. It's not, of course, I don't think it's a problem. I don't think it's a coincidence that the person who was condemned yesterday is actually American for the first time. At the end of a convention who really started controversies, questions, and debates, I'm gonna let myself allow to conclude, not necessarily to conclude as of itself, but to present some work that I'm privileged to be associated with right now about the evolution of the norm framework and responsibility norm of governments in terms of doping. Many things were said today that I'm not going to go back over. So sorry if I look over it quickly. What we know and what we talked about today, I'm going back to my slide, sorry. There's no slides, but it's okay. Perfect. What we know today, and we talked about it, is several points. At the following of the scandal in Russia, of the doping scandal, at UNESCO, there was that element to strengthen that law. Several states, after that scandal, European states, were pushing so that we could increase the responsibility of the government and so that we could increase the UNESCO point. Des Logiques, also, maybe you heard talk about it, gave as a score of a rates of 96% of conformity. While actually, the anti-doping agency worldwide were maintaining their sanctions towards the sports organization in Russia because they were not conform. So we could ask, okay, who's right then? I'm not here to take a decision between both, but the conformity framework of the UNESCO is questionable because it's a score, a rate that is given by a self-declaration without any inquiry. It's just someone who enters a questionnaire and a sport is coming out at the end. While the other way, in the case of Alliance Dopage, we have an exam of conformity of the different elements, which is way deep, with visits, interrogations. With a deeper exam also. So there's a first question or a first failure. That framework of strengthened consequences is from 2014. There's a group of work of jurisdiction in UNESCO that started. I talked with some of them and they are looking for ideas. So if you have ideas in the room, talk with them. I think they will be really happy because they really need it. On the other hand, there's some discussions. In the discussion also that I had, there was in June and May, there were discussions, I think today in Montreal that maybe started. I don't know, Thomas, if they arrived, if you have any information yet. There's discussions that are happening right now about creating a working group collectively of states, sports movement, independence. It's not quite clear, to strengthen the mechanism of working for the government. It's quite actual. Maybe the mountain is going to give birth to a mouse, but when we look at the sport movement, sports are constrained, and especially the high-level sportsmen have obligations that are harder. Sorry for the comparison that we give to people that are suspected of terrorism. We have sports federations that are held close by the Olympic and the anti-doping agency. We have anti-doping agency who have a very strict standards, and we have the labs who are strict also, and suddenly they can lose their accreditation and their food. And some we have government who can do whatever they want. That's what it is, basically. We could have a president, a sport ministry, who gives an order to a federal system, to its anti-doping agency, to put in place a doping system and turn around the system. We could say, okay, Russia is the same thing when we can condemn the Olympic Russian system. For me, it's not the same thing. A state is a state, a cat is a cat. The governments can do whatever they want on one end, because, of course, we understand state doping. I don't know if there are a lot of people, maybe some people are going to plead it, but a state doping is wrong in the term of juridical. Now, everything you can plead, everything. I just want to be convinced. What are the different elements now? There are some elements in the agency anti-doping who are quite limited, actually. We know, we talked about it, the nature of the obligations included in conventions can be discussed. I'm not going to go back over the debates that we had, but it's not that easy, actually. But there are some obligations still. There's no jurisdictional clause inserted in the convention, which is surely why the convention is so successful. Because 191 states, I think it's the best ratified convention administered by UNESCO. So it can be something interesting. We could think about revising the convention, but good luck. Why? Because the mechanism is quite heavy and quite peculiar. Why? It's quite heavy because it's, I think by the Article 30, it's planned, maybe I'm wrong, correct me, 33. Every state can offer an amendment by writing to the General Director of UNESCO. Once that is offered, half the states ratify have to sustain the proposition within the 6 months for it to be presented to the next party conference. And after that, there needs to be a vote organized at that party conference, and that vote has to be accepted with a majority of 2/3. When it's adopted, for it to be opposable to the states have to ratify the amendment or recognize being linked to that amendment. So the risk of it is that if we open the convention of UNESCO again, we have a convention with many speeds. Some states accept to be accepted to be tied, and some states like Russia who say, oh, I'm never going to be tied to that amendment. So only the good players could be linked to that amendment. Other possibility is the possibility of asking an advice to the International Court of Justice. Now, many questions are in suspense. I'm not going to answer to them today. There's political elements. It seems difficult today within the UNESCO. It's not in the priorities of having a consultative element politically, so we could ask about the opportunity, even about the contentious element. There's no judicial element added. Maybe we could think, okay, there's maybe an element that Russia could be there, someone could have tried to talk with Russia about it, but having that judicial court was never done. Ever since 2014, many states cried and saying nothing's happening, but not many did something either when it's talking about acting internationally. But about the UNESCO, many hopes are happening. in terms of many ways, many openings. Maybe there's other opportunities. The path is difficult. I said there's some pathways, but going from a highway, if you don't go very fast and there's traffic, well, the small road might go faster actually, even though you have stops and giveways, etc., and red lights. The pathways, however, could imagine it by going through an additional element through the Convention of Europe. There's protocols that have been adopted. There's more will from the European states. Russia's not there, so maybe it would be easier. But once again, is it really gonna face countries that we try to face through these amendments? I'm not sure about it. Another element, we're going to open them quickly in June, the World Anti-Doping Code. Can we modify it to bringing obligations on governments? It was something that was heavily discussed in literature, also in practice. In the last modification of the code, the 22 article towards the government, I don't know if you saw it, it went from imperative to conditional. The government should to the government, governments have to the governments should. Maybe it's not that hard, we could talk about it, but we could think that within the code there's a disposition. There's already a disposition in the Olympic movement. We could imagine that the code is towards the nationals that violates the terms to take them off away from that doping agency. Could be a first step, why not? Would it be enough? Maybe not. But it could give maybe another element. Of course, you must know that in the anti-doping agency, there's not many Russians. So it would just be to confirm a state situation that we have. And then there's a third proposition that was raised by the new secretary of the football convention to draft a new treaty to create a dispute settlement body. Why not? Why not? But once again, we are back to our problems. How many states are going to go back into it? What are the obligations at the basis of all that? And is it really worth it? Because actually, in the end, if we do have a reglementation element, we could say, okay, the state is responsible. It would just be a reparation element, but would it really, would the sportsmen be okay with that? Would they say it's enough to have discussed with some of them? I don't think so. So I think that the expectation of the sports movement is higher. But can we do it because of international rights? I don't know. And as Mathieu Maisonneuve was saying, is it necessary today, actually? Differently from Matthew, Matthew said we can do it in the city host contract. You said you can do it, but I'm going to say that they're not all respected, and they were not really talked about, or if there was a not respected, nobody said anything. So maybe we missed what we should have done in 2014. Today, when we talk about it in Canada, we're going to talk about it in 2 days, but globally, we talk more about the integrity questions of corruption, bullying, sexual harassment. But doping started as the main point is something that it seems like the public opinion is not interested in it as much. Whether it's in Europe with the football scandals or hockey, it's mainly sexual harassment questions. Doping, yeah, Kenya sometimes. But is it the top priority of public opinion? It's not. It's not. Is it the top priority of some governments? In Canada, they're more into the integrity element than doping. because to change that doping act, it takes a lot of will. And right now, I'm not sure that they have it. So it's something that we could still discuss to work, to do lobbying about that, because it's important to have norms that are effective. And we realized that the violations we got in 2014 from Russia, and maybe from other states tomorrow, are not acceptable, when actually those states do not play with the rules of the game. So that's what I wanted to work on with you. If questions are, if you're interested by question, I wrote an article that is accessible freely online. If you're interested, there's not much to learn from it, but if you're interested or if you want to talk about it, I would be glad to talk about it. I want to thank you and thank you all the people who made possible this convention. I think about the volunteers, the students, our technicians who helped us all day long. Thank you. Thank you to the speakers. Thank you to my co-organizer, Geneviève, Christine, Jean. Thank you to the university. Thank you to RFDE for allowing us some trust. I invite you now to the opening cocktail of the nations. We're going to stop talking about rights now. We're going to talk about something that is a bit happy and soft. The nation cocktail, all the people, even those who are not in the concours, are invited. It's in l'Agora, 3rd level. Right now we're the 2nd level, so it's 1 level up. Where you're in Gora, and we're going to wait for you to the cocktail. Thank you for your attention. I know it's late. We've had a very heavy day. We have a heavy week. And other thing too, we're asking me to indicate, already indicated some of you, there's a terrace next to where we had the cocktail, but the campus is smoke-free. But because there's work being done, it's 9 meters away from the door, so it's a floor level if you want to smoke. Have a good evening, and see you soon.